And once again, we are live here on C-SPAN 2 for the 16th public meeting of the Defense Advisory Committee on Investigation, Prosecution, and Defense of Sexual Assault in the Armed Forces.
Prosecution and defense of sexual assault in the armed forces. This meeting is open. Ms. Bashford, you have the con.
Before we get started, apparently in order to speak, you need to hit request, the green part, and when you're done, hit the part that says speak. That seems odd, but in any event. Mr. Sullivan, thank you and good morning. I want to welcome the members and everybody in attendance today on Valentine's Day to the 16th public meeting of the Defense Advisory Committee on the Investigation, Prosecution, and Defense of Sexual Assault in the Armed Forces, or DAC-IPAD. We're going to begin by taking attendance. General Anderson.
I'm here.
Ms. Cannon.
Here.
Ms. Garvin.
Here.
Mr. Kramer.
Here.
Ms. Long.
Here.
Mr. Markey.
Here.
Dr. Markowitz.
Here.
General Schwank.
Present.
Dr. Spahn.
Here.
Judge Grimm by telephone.
Telephonically here.
Great. Ms. Tokash by telephone. Ms. Tokash?
I'm here.
Great. Judge Brisbois, Chief McKinley, and Judge Walton could not be in attendance today, but with 11 members present, we have a quorum for this public meeting. The DAC-IPAD was created by the Secretary of Defense in 2016 in accordance with the NDAA for fiscal year 2015 as amended. Our mandate is to advise the Secretary of Defense on the investigation, prosecution, and defense of allegations of sexual assault and other sexual misconduct involving members of the armed forces. Today's meeting is being transcribed, and the complete written transcript will be posted on the DAC-IPAD website. We will begin today's meeting with a panel of retired military judges. The committee has not previously had the opportunity to hear the perspectives of military judges who have presided over sexual assault cases. On today's panel, we will hear from 2 retired Army judges, a retired Navy judge, and a retired Air Force judge. And the committee looks forward to hearing from each of you. Following the military judges panel, the committee will discuss the judges' testimony and then take a break for lunch. In the afternoon, the committee will deliberate and vote on whether to approve the DAC-IPAD's draft 4th annual report. The committee will then receive an update from the staff on its 2020 military installation site visits and members' observations of courts-martial. Next, the Army's Chief of Criminal Law, Colonel Patrick Flaum, will provide the committee with a presentation on the fiscal year 2020 NDAA provisions that affect the DAC-IPAD and military justice. The DAC-IPAD staff director has informed me that an individual has made a request to provide a public comment at today's meeting. We will hear the comment after Colonel Flaum's presentation. If a member of the audience would like to make a public comment, please direct your request to the DAC-IPAD staff director, Colonel Stephen Ware. The comment may be heard at the discretion of the chair, and written public comments may be submitted at any time for committee consideration. Finally, the DAC-IPAD staff director will wrap up the meeting and answer any questions the committee may have. Thank you all for being here today. Judges, we are ready to begin. We have your bios, but if you could, please provide us with a short description of your military career, your military judicial experience, and any training you received as a military judge. Thank you so much.
Good morning. Thank you for this opportunity. My name is Bethany Peyton O'Brien. I'm a retired Navy judge advocate and military judge. I spent approximately 9 years on the bench between the trial judiciary and the appellate court. Prior to becoming a military judge, I attended the judges course in Charlottesville. While I was on the bench, I attended various training, some focused on sexual assault, other trainings such as evidence, scientific evidence, courtroom security, and drug cases. But I'm sorry. Thank you. During the course of my career, I spent 5 years prosecuting sexual assault cases. Thank you.
Hello, I'm Colonel Wes Moore, U.S. Air Force retired. I retired from the United States Air Force after 26 and a half years, 6.5 of those on the trial bench. I also served as a staff judge advocate twice. I've served as a prosecutor and a defense counsel, and now work for the Office of Military Commissions.
Hi, I'm Jeff Nance. I retired after 30 years in the Army. 25 of those years I was involved with military justice in some form or fashion, and more than 13 as a military judge. The training we received included what's already been talked about, the military judge's basic course, and then at least twice annually refresher training on various issues of criminal law and military judge business, including training at the National Judicial College in Reno, Nevada.
Hi, I'm Andrew Glass. 26 years in the Army, was a prosecutor, defense counsel, supervised prosecutors, defense counsel, was a trial judge on 3 different occasions at 3 different locations, culminating being a chief circuit judge with Jeff. Went to the military judges course in Charlottesville, which is a 3-week course, twice. In between my first time as a judge and coming back to the trial judiciary, I was a staff judge advocate, and so they made you go back again. In terms of sexual assault training within the context of being a judge, I tried to remember when we started doing specialized sexual assault training, typically in August of the year. It's a week-long course. I think it's 4 or 5 times. Jeff may have a better memory. When we would go and have intensive courses discussing sexual assault cases, discussing evidentiary issues, for example, and kind of procedural issues that were germane to that issue. I also went to several National Judicial College courses. The ones I recall are a death penalty case. I was actually there with Jeff, advanced evidence, and then some judicial art course.
I think the sexual assault training started in either 2011 or 2012 for judges.
Right, and I should say for Jeff, we both attended and presented, moderated panels, et cetera.
Thank you very much for being here. This committee has in the past heard from, we've heard from victims, we've heard from accused, we've heard from victims' counsel, we've heard from defense attorneys, and we've heard from prosecutors and investigators. But this is our first chance to really have questions for people who've kind of seen the whole thing being put together. So I open it up to questions from the committee. Then I'm going to start. What has been your experience with the VLCs and the SVLCs? Has it changed how the courts-martial proceed, in your opinion, in terms of witness preparedness or surprises seeming to come out for which the complainants have not been prepped? And if each of you could just take a moment.
You don't always have to start with me, but thank you. Feel free to jump in, gents. The VLC program really changed sexual assault cases, in my view. Prior to VLCs being involved, and I look back at even my time in prosecuting these cases, it was a free-for-all against the victim, where oftentimes the victim, male or female, seemed to be sort of dragged through the mud. The VLCs really have stepped up and are protecting them. To, I think, an extreme now, because when I prosecuted cases, the victims would come in generally and testify at an Article 32. That was a good opportunity as a prosecutor to see how that individual would fare under cross-examination. They don't have that opportunity anymore. Most victims will assert their rights to not come to an Article 32. Thus, they come into court it seems sometimes unprepared for what is going to happen and how the questions will come at them. As a judge, cross-examination often was the opportunity for defense counsel to really point out how they prepared with the prosecution and completely refused to talk with the defense. I think that's a disadvantage to the government, to their case, if the victim has never had that opportunity and refuses to, as is their right, understandably so. There have been some bad scenarios with Article 32s, as we know, for the victims being cross-examined. But, and I'm using the phrase victim, alleged victim, but I think in terms of preparation for trial, all they're getting is the ability to prepare with the government. And in some ways, that is not doing them a service because they are not having that opportunity for cross-examination at any point or even interviews with the defense. I'll mention that I now have my own practice. I'm a criminal defense attorney. Sexual assault cases are something I defend, and it can be difficult on both sides if that opportunity is not there for victim interviews. Understanding that it's their right, but I think that it would help if they, for the process, would have interviews with counsel on both sides, because then it looks as if, and I saw this as a judge, it looks as if they have something to hide. And we know they don't in most cases, but perhaps they do. I don't know, but it just seems that there's something missing from the process. All you get as a defense counsel now is the CD from an interview with NCIS or CID or OSI, and I don't think they're asking the tough questions either during the investigation. Thank you.
Can I ask a question? This is
I think
Paul
the VLCs have served a great purpose in empowering victims and in preparing them for what they're about to face. The process is a difficult and ardent process to go through, and one of the best things that the VLCs do is to very realistically describe what that process is going to be like. And I think that's empowering for victims. I think before the VLCs, it was kind of up to the variability, the personality of the individual prosecutor in the case, who was pretty much charged with taking care of the victim. But the victim was not the prosecutor's primary concern. And so having somebody whose primary concern is taking care of the victims has had a positive effect. As a judge, I did not find that it was skewing the results one way or the other. I do believe, as Captain O'Brien says, you do have less opportunities to evaluate that testimony, and that's a double-edged sword. As she said, it does have an impact on credibility. It certainly can be woven by a good defense counsel into a narrative that is not supportive of the victim, but by the same token, the VLCs can advise and the victim can decide to testify. I've seen that happen to great effect as well, and to engage in interviews. And so I've seen both. But by and large, I think it has been a positive development. I know as a staff judge advocate in the early days of the program, when they were coming directly out of my manning, it was a difficult transition, but I think the transition proved to be worth it.
Colonel Nance?
Yes, ma'am. I agree with what's been said so far. You know, my experience was that early on in the implementation of the program, the VLCs almost uniformly in the Army had no criminal law experience. And so they were coming in advising alleged victims about things that they really had only a very narrow understanding of. And sometimes, as Beth said, that advice which was designed to protect that alleged victim from abuse, would run counter to the overall object of that victim of having the perpetrator convicted. And so, not understanding the criminal court process, they would sometimes give advice that didn't necessarily advance the ultimate goal of that victim. That said, as time went on, I believe that the training got better, the lessons learned were implemented in the training, and the advice got better, and things sort of evened out. That was my experience. Andy?
So I'll just underline a couple things said previously and then hit a couple different points. I think access when you're a judge matters because your job is to make sure there's a fair trial. And if there is something, for example, the defense hears for the first time in an open courtroom, you have to do something to accommodate that issue, whether that is giving a delay, whether that, and sometimes it can be a substantial delay because there's some new nugget that's come out. And so I think having somebody who understands process matters. Having said that, that's a double-edged sword. Here's why it's a double-edged sword in the Army. The Army does not have enough experienced trial litigators. It is near crisis. The problem is that as kind of the victim advocate program has waxed and waned, it's become politically more necessary to put people with a lot of trial experience in the victim's realm. That has a positive benefit, as discussed by Jeff and the other panel members. It can have a negative benefit because Bob or Mary, who've tried a bunch of cases, are no longer trying cases, and we don't have that many Bobs and Marys. Okay, the reality is, in the current era, there's a lot of people who are trying cases, and it's the first 2 or 3 or 5 cases. Prosecutors and defense counsel trying these cases, which are always narrow, complicated cases, often involving complicated discovery issues, complicated expert issues. You can't be doing this for a first time. You just can't, and do it well. And when the evidence is close, ultimately what that can result in is an acquittal, sometimes when it wouldn't otherwise be an acquittal. The other thing that I've seen as a judge that again derails and slows down the process is in the context of interviews and ongoing conversations with the alleged victim, sometimes material will come out that's what's called Brady material. Those of you who are lawyers understand what that means. It just means exculpatory material. It's required to be disclosed. My experience, again, is often that material is disclosed either during trial or on the eve of trial. And so the reason that the trial gets pushed back is if it's exculpatory material that involves the possibility of expert analysis and testimony, which happens with some frequency, you're talking about a lengthy delay because you have to go through a contracting process that does not work. The contracting process to get expert witnesses does not work in the Army. Just doesn't. It can take forever. It can result in circumstances where you have much more delay than you'd otherwise have to do because of trial dockets. And so the problem is when this process is kind of lurching to trial and this new material is coming out that changes the context and the setting of the trial, when you're a judge, you're just trying to do the fair thing. And the fair thing is to throw time at it and sometimes money so that you have the opportunity to address those issues. So those are the things that off the top of my head seem to me. And I would tell you the victims practice has gotten better. I used to speak at the victims course and kind of say, hey, this is kind of the code. This is what I need from you as a judge. This is how you help your client. And it's gotten better, but in the context of the entire system, it has created challenges that are kind of unforeseen challenges.
I believe Judge Grimm on the phone has a question.
Thank you. Thank you very much. I appreciate your comments, and I think that you had spoken to...
Judge Grimm, can you speak a little more loudly, please?
Yeah, yes. Is that better?
Not really.
Is that louder?
No, Judge.
Okay. Yes. Can you hear me?
You're really going to have to shout.
All right. Can you hear me now? Why don't you pass on my question and go on to the other panel members? For some reason, I'm talking pretty loud, and I know that this phone will work this way, but I think it's on the receiving end. Maybe there's something going on. I apologize. Why don't you go on to the next person?
Maybe he could send in a question to someone.
I think we've got you a little bit louder. Can you repeat the question?
Can you hear me now? Is it better now?
Yes.
Okay. So my question is this. We have noticed that in the statistics that show the outcomes of trials, penetrative offenses when they go to trial, that the conviction rate on the penetrative offenses, the most serious ones, the sexual assault offenses, that the overall conviction rate across the services, but particularly in the Army, is shockingly low when compared to conviction rates, certainly in the federal system, where we don't have sexual assault that often, but in the state system as well. And one of the things that we as a group have been trying to do is to try to come up with an explanation for why that may be. And it's that there are many factors, no doubt. But part of it suggests that maybe it has something to do with the experience of the prosecution and the frequency with which the military assignment system, you get a job, you're in it for two years, maybe 3, and boom, you're off to something else. And for career progression, you're moving out of it, and you may come back to it. So you don't get the situation like we have on our committee, Ms. Tokash, who is a career prosecutor who has a unbelievable career's worth of being in court dealing with cases. And I wonder whether or not there's some correlation between the lack of experienced prosecution and people who develop expertise over a length of time that then allows them to teach others and carry that forward, whether there's a correlation between that and what might be the low conviction rate.
So, first of all, it to me is interesting that you referenced Ms. Tokash. I was her first supervisor in the Army.
But you did a good job.
Yeah, well, I could take credit for that, but that didn't seem honest. She's always been very talented. So the talking point you'll always get about this is that the Army tries cases that the civilians don't, and that is a truth. I will tell you, as a staff judge advocate or former staff judge advocate, I would try cases on some occasion, I wouldn't say habitually, that the civilians wouldn't take, and sometimes they'd be tried to acquittal and sometimes they'd be tried to conviction, and we can talk about that process and how you approach that process. But to me, that's not the overriding factor. The overriding factor is Ms. Tokash used to be an SVP in the Army. There are a ton of SVPs who used to be SVPs in the Army. Ton is, there are not that many SVPs in the Army. But people who like to try cases like to try cases. And when you tell them that they have to go be the chief of ad law after the graduate course, or they have to go do whatever else, it's like telling a cook that he has to go be an auto mechanic. And the reason the Judge Advocate General's Corps tells people they have to do that is twofold. It's a personnelist approach to managing people. I've got X number of slots. I need staff judge advocates. The pinnacle job in the JAG Corps is not to be a judge, not to be a SVP. It's to be a staff judge advocate. It just is. The way you become general officer in the JAG Corps, there's 5, is by what you do operationally and what you do as a staff judge advocate. It's a truth. So when you look at why is this, I think to fix this, you have to break some china. You have to recognize that most of the trial advocates I know, and you could certainly informally talk to people, some of whom are on your panel, would have said, if you just tell me I'm going to be a major my whole life, but I get to try cases, that's what I want to do, or lieutenant colonel. I was told I had to leave being a trial judge to go be a staff judge advocate, or quote, you probably won't get promoted. Now, there's a lot of fixes to that. There are people sitting in who have sat at myriad promotion boards. You can give instructions to boards about relative importance of jobs. You can change your assignment cycle. Specialization in the JAG Corps is perceived as bad or unnecessary. It's ironic to me that we have contract specialists who spend most of their time in contracts. There's an incrementalism. There just is. In 2000, and I can't remember if Jeff was on the same panel, but I sat on a blue ribbon panel. I love blue ribbon panels.
If it was blue ribbon, I would have been on it.
But we had these conversations in 2000, and not much has changed. The SVP program is a Band-Aid, and this is what I mean. There's a lot of really good, talented SVPs. There's some who aren't that good. The problem is there's no SVP for life program, or go be an SVP and we'll make you senior defense counsel. We'll keep you in this realm where you want to be. We'll recognize your particular specialty and build on that specialty. I honestly don't think that exists in the civilian world. There's a lot of explanations for that you'll hear. We have to be able to go downrange and try cases. Sure we do. We need people with military justice experiences as SJs. You don't need that much experience. I've been an SJ. I can tell you in an hour what you need to know to be an SJ and advise people. It helps. You can answer nuanced questions, but guess what? You can call Mr. Nance if he's a civilian working for you and say, hey, how does this work? Because that's how this society works, right? We reach out to expertise. I can't tell you the number of times I was told I needed to do claims or ad law because it was good for my career. Worked out, made colonel, okay? But there's an awful lot of really, really good prosecutors who don't stay in the courtroom. And how do you fix that? Well, I don't know of a way that society fixes that with specialization. When I walk into a room, I don't want to hear that my surgeon just got off of a tour, again, as an auto mechanic. I want to know they know how to fix me up or try cases. And that just doesn't exist. And I think it requires significant change. Another piece of China that you might consider is we believe that the province of military justice is only green suiters, or whatever the color of the suit is now. The suit's changed, it seems like 30 times since I was in. I'm just happy I don't have to buy the PT uniform anymore. But there are almost no civilians, except at a very high level, the highly qualified experts, that are informing the system on a day-to-day basis, that are saying, and then what you'll hear is, well, we can't deploy that. Yeah, you can. You do it now. You take civilians downrange now. Civilian defense counsel go in theater and try cases. So in terms of, Judge, I think it's a great question. I think it's fixable. I think it takes the will to fix it. I know the current Army system, and I know very little about it, has a pilot program. I understand that's how the Army does things. We pilot things. The analogy to me is really a Navy analogy. We're trying to turn a battleship going full speed. I think it requires more drastic change, a greater commitment to changing how we approach prosecution and defense work. And it requires money. It always requires money.
Does anybody have anything to either add or contradict?
I would say my experience in the Air Force has been markedly different than my Army colleagues. I do not recall a case where the performance of the Special Victims Prosecutor was the reason for an acquittal. My experience has been that they've been highly professional, highly effective, highly available, doing tons of cases. I think the real challenge for the Air Force SVP program and the Air Force senior prosecutors in general is that it's just such a grueling job. It involves tons of travel. The Air Force does cases more expeditionary at the various bases as opposed to centralized, which some of the other services do, which makes that assignment a particularly grueling one as a circuit counsel. And I think we lose some really good litigators just to the fact that that's also happening at a point in their personal lives when they're trying to have families, and so they have to make some choices there as to what they pursue. So anything we do in the paradigm to make that job less grueling and more attractive, I think we could attract some better litigators there. But I think currently, at least in the Air Force, we're attracting some of the best and the brightest litigators to the special victims prosecutor, and I've seen them be very effective.
Do you want to comment on Judge Grimm's question about convictions?
There are any number of factors that go into the increased acquittal rate. I will say the chief factor that I've seen in the increased acquittal rate is that beyond a reasonable doubt is a very high standard. Court members do a very meticulous job of applying that standard, and these are very tough cases. And as Colonel Glass said, we're taking cases that perhaps wouldn't be taken in the civilian sector. Whether that's good or bad, we can talk about some more. But that's just an indication that we're taking tough cases, that there is risk involved in that. And the ability to take on that risk sometimes results in acquittals. And they're not necessarily a reflection that anything is wrong with the system. I think the pendulum has swung and is in the process probably of recentering on the prosecutorial judgment on whether cases should go to trial. I think for a long time it was swinging to almost everything needs to go to trial, and if it recenters a little, and I think that can happen in conjunction with the Special Victims Council, giving realistic advice to victims about what the process is going to put them through and what the likelihood of ultimate success would be. I think that pendulum should recenter. It should probably recenter somewhere with a greater number of prosecutions than before it started to swing, but somewhere less than it is now.
I'm curious, now two of you have said that the military takes cases the civilians wouldn't take, and why that is. Was there some, especially given the effects on both victims and the accused of such cases, why it is that the services take cases that the civilians wouldn't? Was there pressure or emphasis that these cases should be tried, or why that is?
I think commanders, first of all, we trust these 2-, 3-, and 4-star generals to protect our country and to keep our soldiers safe, and I think we can trust them to make decisions on referral. I think the commanders, this is a commander system, and it should be a commander system. But I do believe that there's an incredible amount of pressure on commanders with respect to sexual assault cases, and as a human being, their inclination is to say, let's send it to trial and let the judge and or panel members decide. The people that decide those things at big levels, that whether that should be the process that we follow or not, you know, I'm perfectly happy to make them live with the decisions they make on whether that should be the process. But and I think it should be a commander system, and I don't have any problems with that process. If the commander saying, look, I don't know what happened here. Nobody knows what happened here. So let's send it to trial and let impartial judges and or panel members make the decision. But if that's the dynamic we follow, then we have to be willing to live with the results. And the results are going to be where you have bad facts, it's a bad case, and you're going to get an acquittal.
Well, and just to dovetail on that, I agree with all of that. I agree it should be a commander-based system. If it comes out of the commander's hands, I don't think the military justice system is what it is, which is an effective, if used properly, an effective tool for not just justice, but also for good order and discipline. The point I would make is this: there have been myriad high-profile instances where somebody has made a tough call, and that tough call has come up publicly and has impacted promotion. For the less morally courageous commanders, and I'm not saying that's necessarily the world that Jeff's talking about, Sometimes when you walk into that office and you brief and say, I mean, I've been in a brief with a general officer, 2-star general, where I said, sir, we've got these preferred charges. I don't think we should take them to trial. She's not credible. My trial counsel does not believe her. I don't know ethically that that's an appropriate case to take to trial, just under the rules of ethics. And that's where we end up. That's why the case does not get referred, because we're moving in that conversation, which many of you have had with staff judge advocates, we're moving in that conversation to a referral decision where I finally just say, sir, if you refer this case, you need to get a different SJA, a different set of prosecutors, because it is not ethical to try it. That commander then says, got it, Andy, I didn't know you felt so strongly, and we move out. I will tell you, I've sat in another seat where I'm the judge, and that just hasn't happened, where there's just no way the government had a good faith basis to bring that case to trial. And the problem is, front of the mind, back of the mind, with all due respect to the general officers here, little generals want to be bigger generals. Generally, they want to get promoted. It's a promotion-based system. It's how we gauge success. It's hard when there are what are perceived sometimes as unfair shots against their friends to sit there and say, I'm not going to push this to trial, recognizing that 5, 6 years later, 3, 4 years later, sometimes less, there will be an implication that will change your career. So, I mean, we'll talk presumably later about the DOJ standard. I think one of the things you can do is give insulation to those commanders by instituting a standard that is at least and not taking away their discretion, but is at least presumptive, that if you don't meet a certain standard, I mean, there is a standard, right? So there are existing standards, but they're not the standards that we're talking about. And so I think it takes an awful lot of courage for a staff judge advocate and a commander. And we ask them to do that all the time in more important, or not more important, but equally important decisions. And, but that's why we take them. And I took cases, I can think of 3 or 4 off the top of my head that the prosecutors literally would say, well, I'm not touching that, because they know they'd lose and they know their conviction rates come up on re-election.
If I may give a perspective of the Navy, I'll echo what I've heard up here. The Navy, I see it from both angles, both experienced litigators and not experienced litigators. Why is that? Retention. We can't keep good people in that want to try cases. Even we have a military justice track. I spent about 16 or 17 years of my almost 23 years in the Navy involved in military justice. And back in 1994, when I started in the Navy, I was told, don't be a litigator, you won't get promoted. But I wanted to try cases. I joined the Navy to try cases. That's what I wanted to do. And so I spent my first 2 tours trying cases, despite the urgings of my seniors and my detailers to get out of litigation. You won't get anywhere. You're not going to make captain. Well, I did. It worked out for me, thanks to the military justice track, in my view, but I really tried cases. So I did 16 of 22 years and saw a lot of cases. We used to have a saying when I was a prosecutor, we try everything. And if we don't, we put it in writing why you don't go forward. And we would tell commanders, this is why you don't go forward. And let me tell you after interviewing witnesses and the credibility and evaluating credibility, I made a recommendation. And back then it may not have been followed in every case, but at least the commander had a letter to rely on that was a prosecutorial merits memo is what they call them now, it seems, in the Navy. But we would tell them, don't go forward. And here's why. They often would choose to go forward anyway. Okay? I will tell you, I had a losing record as a prosecutor because, back to what I said earlier, we tried everything. So now, what I would say is I think, and echoing what I've heard up here, some of the commanders don't have the ability to make that tough call. Should it go forward, should it not? Because of some of the potential ramifications to them. Yes, little generals want to make big generals, but commanders want to make captain too. And so if they're seen as the not being tough on good order and discipline and ignoring the desires of the victim, that has ramifications for them. But when it comes to senior prosecutors, we used to try a lot more cases than we do today. And we would cut our teeth as baby prosecutors on the unauthorized absence, the AWOL cases, the drug cases. We'd cut our teeth on those small little specials. We don't have many of those anymore. A lot of that goes the administrative route or the non-judicial punishment route, so you're not having the opportunity for litigators to really try cases. And then in certain areas right now, even in the Navy, there aren't enough prosecutors. There's not even enough support staff. Prosecutors are making copies, and they can't keep up with discovery obligations. Thus, we end up, as judges, now having to take up discovery issues right before trial because the prosecution can't get the work out to the defense. That impacts military justice and how cases languish in this system. I mentioned that I'm a defense attorney. I have a case that I'm defending where it's been around for a year, and it's still not moving anywhere. I mean, a year seems like a really long time for a case to be in investigation and then under consideration by either the prosecutor or the command. A year is a long time, both to an alleged victim and to the sailor who is facing potential action in the future. It's a grueling job to be a prosecutor, or it can be. It can be also very professionally rewarding. But we have prosecutors as lieutenant commanders who are saying, I've had enough, I'm leaving. Because they can't be prosecutors, they can't get support for either staff or other prosecutors, and they leave, they punch. I mentioned I spent 9 years on the bench. So my process was 2 years trial bench, 3 years appellate bench, 4 years trial bench. I was told I could no longer be a judge. I had to go back and be a staff judge advocate. After 16 years of doing military justice, I was told you need to go be a staff judge advocate now. We have no more military justice job for you. So I retired in 2017 because I was told there was nothing more for me in military justice. So if we're telling the judges after so much time that they have to leave, and we're telling the prosecutors they can't try cases, or even the defense counsel that they can't litigate, we lose good people. But the commanders, going back to, they need to make the tough call and often don't. And I understand that they send cases to trial that would not otherwise go to trial. I was one of those prosecutors that took those cases to trial. But we need to put people in command that can make those tough calls. Even at the prosecution level or the defense counsel level, if we're putting non-litigators as commanding officers of litigation shops, then that's a problem. Because you're having commanding officers who are operators supervising the prosecutors. And the operators haven't been in the courtroom in a very long time. And they don't know prosecution. They might know how to be a commanding officer, but they don't know prosecution, they don't know defense. So we may have to look at how do we select who is in charge of those various offices. Thank you.
My experience with cases that were declined in the civilian system that we went forward with is generally those were local state level prosecutors that were declining those prosecutions. And there's just a different set of dynamics that goes into the prosecutorial decision. A staff judge advocate and a commander doesn't have to run for re-election, for instance. It doesn't have a conviction rate to protect. And it's generally, your conviction rate's not something that's going to determine whether you were successful as a staff judge advocate or not. And so in that regard, having the greater latitude to take some of the tougher cases to trial is not a bad thing. I think it's a good thing that we're taking some of those cases. Should we be taking everything that we're taking to trial now? I don't think so. But the fact that we're taking some of the harder cases, I don't think is a knock on us. And the cost of that is that the acquittal rate is going to be higher. But I think we can manage that cost. I want to take a contrary position to my colleagues, or at least state the contrary position on the specialization. I was a specialist for a while, then I went and specialized in something else, and then I went and did the staff judge advocate thing on a couple of occasions, and I found that that actually was helpful. I believe that being a staff judge advocate made me a better military judge because as a staff judge advocate, you're working with commanders, you're working in the trenches, you get a better feel for what's actually out there going on in the Air Force. I also believe that the best way to train the next generation of new prosecutors is in that staff judge advocate office because as a lieutenant colonel staff judge advocate, I was getting in the new lieutenants fresh out of law school who were raring to try cases. And the best way to develop them into the litigators is to have former litigators in that staff judge advocate's office to train them up and to show them how it's done. So there is a case to be made for specialization, but generalization also has its benefits, which can't be overlooked.
Okay, Ms. Cannon and then Ms. Tokash.
Thank you for your comments. Regarding the question of commanders making the ultimate decision and some of the competing interests that they might be troubled by, including ethical issues, we've discussed among ourselves here on the iPad the issue of the preliminary hearing and how that is or has been at times a vetting process for cases where there is actual evidence introduced and where you can see what a case looks like. I'd like your thoughts on preliminary hearing officers having binding decision-making capability when they come to the issue of probable cause, and if that would have an effect on insulating commanders with regard to those decisions.
I'll speak to this first, I guess. You know, I thought about this, and I think there's pluses and minuses to both sides of that question. And what I came down to was what I thought is kind of a hybrid preferral process. And here are the 5 elements of it that I came up with. First, the General Court-Martial Convening Authority can send the case to a binding 32 for any offense, not limiting it to sexual assault offenses. Otherwise, the default is to the current Article 32 standard. Second element. At that binding 32, the investigating officer would need to be an active duty or reserve component military judge or a full-time magistrate judge. More on that in a minute. Third element, probable cause is still the standard. I don't see anything wrong with the RCM 406 standard as it now applies, and that's the same standard that's applied in the civilian criminal justice system. Fourth element, the government can come back with new evidence if no probable cause is found and re-energize the hearing. And then the fifth element, and this might, I don't know if this will be controversial or not, but only a no probable cause finding is binding. This preserves the General Court-Martial Convening Authority's authority to, and it does not erode the current important protections for an accused. I think that this concept of a full-time magistrate judge would be a senior 04. They would, as opposed to our current part-time military magistrates, they would do nothing but magistrate duties and do 32s. They would supervise the part-time military magistrates, and they could help the actual military judges with important rulings on controversial motions or whatever. But I think as I think about it and have thought about it, I think something like that might work. And it might provide a sort of an escape valve for the commander who is under a tremendous amount of pressure on some of these sexual assault and high-profile cases. And it's, you know, it's tough at the top. And like I said before, I think sometimes the decision is just to say, well, on a close case, we'll just let the panel decide or let the judge decide.
So for a number of years, Jeff and I worked together on the Military Judges Bench Book Committee. He was my boss. You know why now. I endorsed the the Nance proposal, but I would note a couple of issues that you're going to hear. One of the issues you're going to hear is, at least in the Army, at post, camp, or station, there's often only one judge. Most places, there aren't multiple judges. And so, are you really going to, at Fort Riley, at Fort Drum, add an 04 billet that works there? I mean, that's one of the logistical, that's one of the pushbacks you're going to get from, I would guess, I don't presume to know what pushback you would get from the services, is we don't have the bodies. The thing I like about Jeff's proposal, beyond just the fact that it puts it in a little different box, is that, and I think a more favorable box for the system for the commanders, a more favorable box for the soldier, the service member, but it also allows you to start to develop judges. Your 04 magistrate in this system would be able to get some reps. One of the things you're going to hear over and over again, to use a sports analogy, is, you know, my son is swimming in regionals today, hopefully doing great. He doesn't get to be good unless he gets reps. But we expect trial advocates and military judges to be good without getting repetitions. Okay? That 04, whatever we're calling them, chief magistrate, gets some time in the saddle where they get to make decisions. One of my best jobs was as a part-time military magistrate, as a captain at Fort Bragg. It was, I didn't know at the time, a stepping stone job that helped me to be a judge. And so I think it does provide a benefit. My only concern is, and it goes back to the normal Army issues, right? Staffing, et cetera. I think one of the questions that we were told might be asked of us was, how about judges doing preliminary hearings? And the problem is, when I was at Fort Drum, I don't have the time, and there's one of me. You know, and if you're going to say bring a reservist, reservists have life issues too. They're not always going to be available. And some of the other issues that you're concerned about, timing, how things move through the system, again, experience, those become issues.
And then
as
if
well.
if you're the judge that's done the 32, you're not trying the case.
Right.
I will say in the Air Force, judges do almost all of the Article 32 hearings for sexual assault cases. I did several when I was a judge. We really handled the logistics issue by doing most of them by video teleconference. And so we could do one in a morning many times and spend the afternoon writing it up and still have it done. So at least in the Air Force's experience, we had the manning, we had the ability to do that. I think it did add value. And I think if a military judge is making a no probable cause call, then there's no reason that that should not be binding, at least subject to the opportunity to come back and present additional evidence.
I agree that with the proposition that an Article 32 no probable cause determination should be binding. If the government has an opportunity later on, if new evidence is found, then they can come back and revisit it. What I see, though, as the problem with the preliminary hearing currently is it's almost a foregone conclusion, because the government's obligation is to walk in, and while I agree with the probable cause standard, how they're meeting it generally in the Navy is to walk in with an investigation and give it to the preliminary hearing officer and say, here you go. No cross-examination of witnesses, no testimony. They just drop a paper case on the preliminary hearing officer. So back to some of my earlier statements about alleged victims not testifying, well, many witnesses aren't testifying. Most witnesses aren't testifying because the government's position has been, in most cases, is we don't have to bring in testimony because it's cumulative with that report. Despite defense counsel asking for witnesses to come, in many cases the witnesses aren't, because either they're civilians and they decline, or the government's position is that their testimony is cumulative with the paper. So are you really vetting a case out based on paper? I would submit that maybe not. You're not really getting into the issues of the case. And in the case of the Navy, I don't know if the Army and Air Force are doing it differently. I have to assume, because their investigators are uniformed, we have NCIS declining to appear, claiming they're civilians. They don't have to. So that's causing a lot of discussion amongst preliminary hearing officers. Our preliminary hearing officers, while sometimes we do use the judiciary for the more serious cases, it's usually a staff judge advocate from another command that here's the case in 03 and 04, sometimes 05, hearing the evidence. I was a staff judge advocate as well. I mean, I didn't specialize in just military justice. I was a staff judge advocate. Some of our junior staff judge advocates don't have a lot of military justice experience either, and they're making recommendations in maybe their second tour. Let's assume it's a second tour lieutenant. They didn't try very many cases in their first tour, and now there's a staff judge advocate weighing the evidence at a preliminary hearing officer, the evidence which consists of a report and no testimony, not even by the agent who investigated. And I think that is a hollow process. You're not really getting to the evidence and what exists other than what is in an investigation, which may not be thorough. It seems the agents have a checklist that they use for investigating sexual assault cases, and so they're not really delving deep into some of the issues that might exist that are credibility issues that would be important to know at the preliminary hearing phase. Colonel Moore made a comment about in the morning he might hear a 32 as the preliminary hearing officer and in the afternoon write it up. That tells me that sounds like a paper case, right? We drop a report on in the afternoon, all he has to do is review it and write it up. I would think that that might not have been a thorough 32, all due respect to Colonel Moore, but did the government really present the evidence other than what was written on paper? And while I understand that's what the rules allow for, the rules also allow for the defense to have that opportunity to present witness testimony, and it seems they're not getting that opportunity. Thank you.
Ms. Tokash and then Ms. Long.
Thank you. I hope you can hear me okay.
Megan, you're going to have to speak louder.
Okay, can you hear me okay?
That's better.
Okay. From where you sat as judges and where you sit today, what impact, if any, does the lack of a required prosecution standard akin to the U.S. Justice Manual have on acquittal rates? And would a standard that you must have admissible evidence sufficient to obtain and sustain a conviction be helpful? So in other words, are the military services really taking harder cases because of the facts, or is the military labeling them hard because the military doesn't have a prosecution standard akin to federal civilian prosecutors?
I'll take the first shot at that one. I think that higher standard would actually remedy the observations that Colonel Peyton O'Brien has about the pro forma nature of the Article 32 investigation. The reason that there's not a lot being presented at the Article 32 investigation now is that there's not a lot that's needed to meet the probable cause standard. So to me, if we're saying that we need to bring more information out of these investigations, what we're really saying is that we need a higher standard. And so I think that's the question is, do you want someone to look at the case just based on what's there, what's minimally necessary to establish probable cause? If so, status quo, continue as we are. If you think you need more information, if you think you need to evaluate witness credibility, well, that doesn't go into probable cause, really. In that case, you need to have a higher standard, and maybe the Department of Justice standard does make sense.
So when we talk about discretion, again, I hate to beat this drum, but it's relevant. Who's making that discretionary call? You can impose a higher standard, but if that discretionary call is an experienced prosecutor making a recommendation to somebody who has experience in the process, that's a different discretionary call than somebody who has 2 or 3 cases making a recommendation. And it does matter that the prosecution standards are different. They're dramatically different. I would tell you, I've sat in cases, and I believe this to be true, where I would look and I would think, how are we hearing a motion to dismiss a sexual assault case at a very, what's called an RCM 917 motion? How are we even hearing this? Why are we here? Because that's not a credibility determination. That's just the base level facts. Have they met this burden? Meaning the government, have they met this burden? And if you're there, that tells me there's something really wrong with your case, which happens, right? Sometimes witnesses don't show up or change their testimony, or that you didn't fully consider whether this case should see the inside of a courtroom. Now, does that happen a lot? No, it absolutely does not. I don't want to overstate that. But to have it happen once, to me, is problematic in that system, because that's an ethical call a lawyer ought to be making. I'll tell you, I sat as a judge a number of times ruling on motions where I would have both sides present evidence, facts, whatever. For example, one time I had a motion where the relevant issue was, when did the Article 32 change? That's a fact. That's a fact. Experienced defense counsel, experienced prosecutors did not give me that fact. If done intentionally, that's an ethical violation. I don't think it was done intentionally, so there was no ethical follow-up. But it's an ascertainable fact. You know how I know? I Googled it. It exists. I took judicial notice of it. But the reality is that at the end of the day, yes, I think it would make a difference, Megan. I think it'd make a huge difference in having a standard. It would insulate people in the system. But at some point in time, it doesn't fix all of the issues that are out there. And I want to make sure there's one clarifying point. I think SVPs in the Army are amazing, talented people. I'm not besmirching that program. I'm just saying it's not enough. Ultimately, if those SVPs go on to be older SVPs, they're better going to be able to inform a system, inform commanders, and make that system work.
And I would just agree with what's been said so far about the standard, and just sort of refer back to what I said earlier about what is our purpose. And if our purpose is to get more convictions on sexual assault cases, then having a higher standard will reduce the number of bad cases that judges hear or panels hear, and reduce the number of acquittals in sexual assault cases. If the object is to give a sort of pull back the mists of uncertainty that the public might have about the military justice system by having all cases go to trial and live with the results, then I'm not sure a higher standard is going to achieve that goal.
Okay, thank you for being here. Before I ask my question, I do want to be the dissenting voice that I don't think that we can actually say that your acquittal rate is any better or worse than the civilian world, because we don't have that comprehensive data. And I think everyone always thinks they're taking cases that the other doesn't take, and I think that that's true in a lot of, and you have certainly sat someplace where you know your civilian jurisdiction hasn't taken something that you have, so that's definitely helpful. But I did just want to, for me, I just wanted to put that out there so that there's some comfort that I don't think you're chasing you're different than any other standard right now. My question is on the Article 32, and since a lot of you also have civilian experience, you know that preliminary hearings in the civilian world are definitely more than what you've described the current Article 32 is, but not necessarily a full and open discovery piece where defense witnesses are called, although they can be. Can you envision a system, a process in the Article 32 where it is different than it is now? It's not a paper, but it also isn't a full hearing, basically, where you're determining issues that are not necessarily relevant at the probable cause standard and maybe would be then determined by the SJA if there was admissible evidence or other things to go forward. Can you envision a hearing that would be protective of victims but also fair to accused and fair to the process than exists now? Because from what I'm hearing, what you're saying now about the paper, that doesn't seem to be satisfactory based on your experience.
I'll start. You seem to be looking at me. So
while certainly as a defense counsel, it would be great to have opportunity to cross-examine a victim. I'm not talking necessarily about that for a fair hearing or even a thorough hearing. Because victims decline, as is their right to be present at the 32, and I've seen some that do come in. They're willing to do it. But then when you use a paper case, when it's the agent's interpretation of what was said, summarized in a report, which may or may not have some sort of, I think there was just a change in the volume, but I lost my train of thought there for just a moment. When the agent puts on just the report, or when the prosecutor puts on just the report, which may or may not have the testimony or a statement, verbal, an audio or a video, then we just get a summary, which is not helpful in the process. And when you have an agent that declines to come in because they view themselves as being protected under the rule as a, quote, a civilian, and I would disagree. I believe that if that had come to me as a judge, that I heard a motion for a new 32 because the agent didn't come in claiming they were a civilian, I believe that would have been something I sent back for a new 32, because I don't believe that our civilian law enforcement who work for the Department of the Navy can claim they're a civilian and don't have to testify. But if that's the only person that comes in, and I've been part of civilian processes where at a preliminary hearing, the only person that came in was the police officer, at least there was some testimony that, while I understand it's not a full discovery avenue for the defense, it's also just an opportunity to see what's there and present some of perhaps defense evidence that might go to that determination of probable cause. If as a defense attorney you don't have that ability, then all that needs to be presented is that little bit of evidence to get over probable cause, which, as we know, it's a fairly low standard. Do I think it needs to be back the old days of when it was an all-day 32 and we paraded all these witnesses in? No. I think there can be something in between. But to claim that any witness who testifies, and this seems to be, at least from my perspective now, what's happening is the government claims anybody who testifies, if their name's in the report and they've given a statement, then their testimony would be cumulative. I would disagree that that's always the case. I think as a defense attorney, when I talk to witnesses and interview people, there's probably something I find that I would like to present. I can't do that if they're not there, because the government has said, well, they're cumulative, and oftentimes the preliminary hearing officer will agree, I have a report, I don't need the person. I think something in between, because you need to explore some of the issues. And it's not a full discovery tool like it used to be, but the defense still does have an opportunity to put on witnesses. It's in the rule, and it's not happening. And I think if they had that opportunity, it would be a more thorough investigation, at least for that credibility or that determination by the commander who has to make that call when they receive a report, if a probable cause standard was met, and we see those recommendations, yeah, met, but don't go forward, and here's why. Or go forward, but no, you're going to lose. And don't get me wrong, I don't believe the objective should be, let's just get more convictions. The objective should be present the case. If it's going to trial, let the process take place. And the objective of the 32 shouldn't be to perfect the government case or to poke enough holes so it doesn't get probable cause, but at least so that there is an evaluation of the evidence. Thank you.
I think, again, the standard will drive behavior. If the standard is probable cause, I don't think any prosecutor is going to show any more of his cards than he has to meet that standard. And so if you think that more needs to be done, that more needs to come out, then the answer is to raise the standard or to change the rules of admissibility at the Article 32 investigation, perhaps. I think any change to the rules, prosecutors will adapt and overcome. So certainly I think any any modification is easily enough implemented. I think we've seen adaptations to changes over the last 5 years that everybody's handled with aplomb. So I think it's certainly doable.
But Colonel Moore, just to follow up though, but the civilian standard at preliminary hearing is probable cause, and there's not this issue. So would it have to be a change in standard at the hearing for there to be a change in behavior, or do you think the Air Force or the people that you had seen in the courtroom could change the behavior?
You probably change the underlying rules as well. And so, for instance, Captain Peyton O'Brien mentioned the cumulativeness standard. And so maybe you tighten that up and you have a broader definition of what's, or a tighter definition of what's cumulative, or you eliminate cumulative as a basis altogether. Or you have military judges who feel a little bit more comfortable standing up to the prosecutor and saying, I want to hear from this witness.
I think a more robust Article 32 hearing would be useful in providing information so that the person who makes the decision about referral has the most information available to make an informed decision. And I don't know, I'm a simple guy. I don't see how that's a negative thing.
So we think there's a public benefit, and I understand that these hearings would be closed at certain critical portions, but we think there's a public benefit to this being able to be on TV today. I joked with Jeff that if one of the good reasons that we don't have TVs in a military courtroom is what that gentleman did before. I would have found him in contempt. Okay, I know he's doing his job, but my point is that we believe that this has a public benefit to being out there. What public benefit is there to a paper case, and what does it do to the presumption in society that this really isn't a justice system? So that's the first point. The second point, and this is, I know these things are numeric as can be, and you maybe already have this statistic, but if you don't, and I know that all the various departments are going to love me, this table over here is going to hate me, but I would look into how often in sexual assault cases the 32 is waived by the defense. Because they don't think it's fair, because they don't think there's any benefit, and because they don't think that anything good can come of it. So I would check that if I were you. Then the other piece, if a judge doesn't have comfort standing up to a prosecutor, whatever the rules, and making sure something is fair, let me say that a little more positively. The judges here at this table would have no trouble saying, nope, we're going to hear this case, or nope, I'm going to allow some latitude. Now, there's no doubt, and I don't know the specifics of some very, very public misuses of the Article 32 system in the past, but there's no doubt that there have been some misuses and abuses in the former Article 32 that resulted in this change. I think there is a middle ground, and I think to the degree you can get somebody who knows what they're doing, who's been trained what they're doing, whether they're a major or a lieutenant colonel or a colonel, sitting there saying, nope, I'm going to allow this, or nope, you need a little more. I think it makes a difference. It does matter.
Mr. Kramer.
I'm sorry to switch topics for a second. I wonder what you think of the ability of defense counsel to obtain experts and the procedure they have to go through to do that, and whether that should be changed?
Sir, I've preached on this for my entire time in the military. I think it should be changed. I think it's difficult to impossible for the defense counsel to get experts. I think having it approved by the prosecutor is the wrong answer. I think the defense bar should be, or TDS in the Army parlance should be funded, and they should have at the TDS headquarters level a warrant officer who's in charge of dispensing money for expert witnesses, and the chief of TDS is the adult in the room who makes sure that there are no abuses for frivolous. And of course, the judge is going to do that too. I mean, the judge ultimately gets to say whether an expert gets to testify or not. But I think that's a better dynamic, a better system for experts for the defense bar.
So I agree with all that. I would just say this, and I think this has changed. I'm not conversant with what's going on in the Army in terms of the Trial Defense Service. But sometimes you need an expert to be able to establish you need an expert, right? So somebody's got to come in and testify and say that this is what I'll provide to the court to persuade that judge that this person should be allowed to testify. I think there's money. I know, again, years back in Trial Defense Service, that was a big conversation. I mean, hey, how do we do this? We can't get there without, and it's the rare expert or the very dedicated expert that's willing to come in and testify to establish that they're needed. And so,
for free.
Yeah, for free. Because if they don't get retained, they're not getting that back. And so, yeah, absolutely. I think I want to echo what Jeff said. There needs to be a pot of money that the defense can go to, and I think now with investigators also, so that you can establish that kind of baseline case for that additional assistance.
I think the current system has actually worked fairly well in the Air Force. I generally, more often than not, would see experts that I did not have to compel as a military judge, so that they were getting appointed and funded. That's not to say that Colonel Nance's proposal isn't superior. I think the fact that I'm saying it works in the Air Force and it doesn't work in another service indicates that the process is not as good as it should be. It shouldn't depend on one service's implementation of it. And to that extent, having trial defense services in charge of it does make sense. You're still, as a judge, going to have those circumstances where the individual defense counsel doesn't agree with his boss's decision, but I think you're going to see a lot fewer of those than you do disagreeing with the prosecutor as he advised the convening authority on granting that expert.
I have actually tried a case with Colonel Moore as a defense counsel, and I will say that I was surprised because I came from the Navy that the Air Force did it, in my view, so well. There were multiple experts granted by the convening authority, but in the other services, we struggle as defense counsel to get experts just for purposes of consultation. Do we need an expert? And convening authorities often, more often than not, deny that. And I think that for defense counsel, that's a difficult road for them when they are trying to evaluate their case. They think there's something there. They're trying to find somebody who might talk to them for free. And as defense counsel, we all have sort of that group of experts we can reach out to just to, have that 5-minute conversation. Do you think there's something there? They won't charge us. But then in order to do the evaluation, they need to be appointed. And convening authorities resist. I do a lot of appellate work now, and I read records of trial, and I'm often shocked. I guess I shouldn't be because I know this is happening, but I'm often shocked at how many pages of transcript I'm reading with the government fighting over experts. Hundreds and hundreds of pages on motions, and the court not granting experts, or ultimately granting the expert after a day of testimony and fighting back and forth. And I think the system needs to be changed to allow the defense to have that opportunity to seek consultation, because we know the government has it, right? They have all the tools at their disposal they can call. Although I would say that maybe even in the Navy medical system, many of the experts don't want to be involved, and that presents a trouble for the government as well. But I think the current system does need to be improved upon.
Why is that they don't want to be involved?
I don't think anybody relishes the idea of having to testify in court, no matter what side you're on.
Plus, it's an hassle.
And
Takes away from what they're doing on their day-to-day.
Right, our military medical system is overstressed just with patient care. I mean, see what's happening with dependents and retirees. They're not necessarily seeking treatment at the medical facilities anymore because they can't, there aren't enough doctors, not enough time. So now you have a doctor who sees patients and has to be an expert, and they're just they don't want to get involved. There are some who love it, they want to, but I would say that oftentimes you'll find the medical, because they're stressed on just doing patient care, they don't want to be involved. So we then look to the civilian population. There are plenty of civilians out there who do this for a living, and I would say that I think the Navy has a pretty good pool of who they utilize, and it's probably shared with the other services as well. But it is difficult to find the active duty to be involved.
It's a great segue for Dr. Markowitz.
So this is an issue near and dear to my heart. I'm interested in hearing from all of you, because the services do use experts differently, whether or not you believe that experts are being used effectively at trial.
So in the Navy, I would say that in the sexual assault cases, there would be experts involved. In every case that I've ever tried, whether I was a judge, trial counsel, defense counsel, there was some sort of expert involved. Do I believe they were effective? Well, I think that sometimes is expert specific, but we're talking DNA, we're talking computer forensics. There's this phrase that often is batted about cases are so much more complicated today. I would tend to disagree that the cases are more complicated than they were 20 years ago, perhaps except with computer, cell phones, you know, the Snapchat where things disappear. Maybe that side is a little more complicated because of just the forensics that goes into that. And if you have trial counsel who are young, who don't understand the computer forensics and the phone, that can be problematic. And I see it in transcripts I read, and I saw it when I was a judge. I mean, I won't tell you my age, but I can tell you that my 16 and 18-year-old kids are way more proficient on the iPhone than I am. I hand it to them, hey, screenshot this, man, I'm not sure what to do. So if I'm a judge and I have that difficulty, we can imagine that maybe some of the counsel do as well. But do I think they're being used effectively? I think for the most part, yes. But is it a fair playing field? I would say no. I think that with the defense, and we go back to your question of having to ask for the experts, you know, kind of sort of begging hat in hand, please give us an expert, we need it for this. And oftentimes, the court might say, well, you should be experienced in this, you've done enough of these cases. I know as a defense counsel, when I seek experts, I often do get the response back from the government that says, you were a judge advocate for 23 years. You were a judge for 9. You don't need an expert. You're fully versed in this. But I can't testify. So they tend to miss that part, that I need a consultant to help me who may turn into an expert. But they're denying because of the experience level of just the counsel. Admittedly, you know, the case law indicates that I should educate myself, but that only goes so far. And oftentimes we need an expert.
I would say most of what I've seen from experts has been that they have been very helpful and very well employed. What I saw in the Air Force practice was the same handful of experts over and over again, working equal number of cases on the prosecution and on the defense side, which gave them great credibility. I can recall a few cases where the experts were advocates in disguise, and that was very easily revealed throughout the course of the court-martial, and they were not effectively employed, and they were not persuasive, and had a really negative impact on the overall outcome of that case. But by and large, many of the issues that we're dealing with, and particularly in sexual assault cases, I've been much more enlightened by hearing from experts. Alcohol is almost always involved, and so the education I've gotten on issues like blackout and on the effects of alcohol on memory, those are invaluable to these court members and to a judge sitting as a court-martial in evaluating all of this evidence that you have before you. So my experience has been, it's been very effective, very helpful, and the experts that I see on a regular basis have been very, very professional, neutral, tell it as it is, and have been very helpful.
I agree with what Wes said. When an expert gets to trial, my experience has been that most of the time, a vast majority of the time, counsel, both defense counsel and trial counsel, do a good job of getting the pertinent information out of that expert in a good way, in a good presentation. I think they struggle, and I think that's because the expert helps them, design their direct or cross-examination. But I think where they struggle is in the decision and in figuring out whether or not and how they need an expert and how to get the expert. And that's a product of lack of experience. But I want to just add to that I think the HQE program, at least I don't know if the Air Force or the other service said, but I think the HQE program, particularly in the Army, they do a great job of helping young counsel understand the expert process and helping them make the decision about whether an expert would help their case or not. And I think that's the question that young counsel struggle with the most. Do I really need an expert, or am I just hypersensitive about ineffective assistance of counsel and asking for an expert when I really don't need one?
So I just want to echo what other panel members have said. I think discernment matters, right? So discernment of not just do I need an expert, but what are the consequences to the timeline of my case if I call an expert, because often you're going to get a kind of concomitant defense request for, an opposite expert. And also, what are the consequences in terms of evidence that is now admissible or approaches that are now admissible? And you don't always see that. I would say, just to echo again, the testimony I've heard in my courtrooms from experts has almost uniformly been, when given, professionally done, usually professionally cross-examined. Sometimes I've wondered, why did he or she testify? Especially when I'm the fact finder, I'm like, well, why did I have to hear this? Or what did this add to in terms of the development of the case? I've had instances in sexual assault cases where experts have been almost dispositive because it just strikes me always with young counsel. Judges like to learn. Those of you who've been judges, sitting on the bench every day can get kind of dry. And so learning and developing an understanding of how this works, a good expert is a good educator. And so that certainly has been interesting. I want to give you a contrast. I'm not sure exactly what it means, and obviously we can't fund all cases like this, but I had the honor to sit as a defense counsel in a capital murder case. And when you talk about experts, because death is different, it's pretty much like a candy store of experts. You get all you want. And it is at least striking to me to see the contrast of all you want versus we can't figure out getting this expert to trial to give both sides an adequate opportunity. It rarely, in my experience, and the others can certainly correct me, it rarely, in my experience, looks fair for Dr. Jones to come in and testify for the government. And if any of you are Dr. Jones, I apologize. Dr. Jones to come in and testify for the government and there be nothing on the other side. So I'm not saying it can't happen. Obviously, the standard allows that sometimes. But in a capital world, for good reason, there are millions of dollars spent on expert witnesses. It seems to me that there could be a greater balance in how we approach that.
Ms. Garvin and then Ms. Long.
Thank you. Thank you all for being here. I have an intentionally broad question so that you all can take it where you want. And it's a compound question, but you all can't object to it, which is fun to have judges on the other side. But really, I just want you to share your experiences with 412 and 513, and particularly as the SVCs and VLCs have been involved in those. What have you seen, hopefully post-2015 when they were amended? But if not, that's okay too. And with the constitutionally required exception, which I find odd as an explicitly drafted exception, because of course it would be there even if it wasn't explicitly in the language. But what are your experiences? How are you seeing that impact trial? Are you seeing an impact trial? And what are you seeing with the role of the SBC-VLC? And truly, wherever you want to go with 412, 513, it's been something that has been talked about quite a bit by this committee, by other committees, and would love to hear the judicial perspective.
Sure, I'll take the tough legal question first. My experience kind of runs the gamut from the old 412 to the newer 412 to the new 412, and 513 doesn't exist, simple privacy issues, and then litigating and expanding how we look at 513. I would say generally that victims counsel in the Army, in my experience, are really good on 412, and I don't know if it's because they've been collaborative with the government, but are really good at saying me too. I don't get a lot of new, nuanced arguments about, or I didn't get a lot of 412 or 513 from victims counsel where I said, that changes the landscape. In that context, one of my concerns as a judge, as the 513 system evolved, was I had a couple of cases under the old 513, or maybe under a misunderstanding of 513, where medical records came in, were disclosed under a protective order, and were huge in a determination of judicial guilt, but may have also been huge in a determination as to whether this thing ever happened. I've had instances, not recently, obviously, follow the law, but I had instances where there were personality disorders disclosed in the release of medical records that went directly to the claim. And frankly, in one of the medical records said, well, I won't give the specifics, but gave facts that undermined the original claim of sexual assault, and had a diagnosis of a personality disorder that was among the DSM criteria, has a difficulty telling the truth, which, that's huge. And so having litigated it under a different paradigm and released it, sure, the defense had a heyday with it. So my concern, I guess, as a human and as a judge was always, what don't I know? Right? What is out there that I haven't seen that may, a year or 2 years, maybe never, implicate whether or not this was a just trial, whether this is a just process, whether this was a just verdict. So that's kind of my observations of the system.
Yeah, and just to sort of dovetail on that, I think my experiences were similar to Andy's because our time in the judiciary sort of spanned the same time frame. So I lived with and experienced myself and struggled with the implementation of the rules as they changed and sort of coming to an understanding of what was required and how logistically to go about it. I'll say that unlike my current job as a military judge, I didn't have a law clerk. It was me and me alone, and so when I would get a stack of medical records this high to go through and try to see if there was something in there that needed to be released, man, I didn't have the time to do it. I really didn't have the medical expertise to be able to do it, and I was always afraid I'm going to miss something that should be released and not release it because I just don't know what I'm looking for, or because I don't understand what I'm seeing. So that was always my fear. I mean, maybe that was a good thing because it made me more vigilant in reviewing those things. But it really was a burden as a military judge to try to have to go through that in the midst of a hotly contested trial when I had a lot of other things to do. Yeah, I mean, I think that though as counsel became more experienced with it, I saw the requests in those areas sort of shrink, not just in terms of numbers, but in terms of the scope. So they learned to narrow their scope and figure out what they were looking for, which made life a little bit easier, and I think made the chance of making a mistake reduced. From my perspective, the military judge reduced the chances of me making a mistake on that front. Wes?
Colonel Nance, 513 made the job of reviewing psychotherapist patient records immensely more difficult. Sometimes you have to do the difficult, and so the other side of that is I think we do a much better job of protecting those confidential records than we did before. I think the default position before 513 was release everything subject to a protective order, and then we'll just fight whether it comes out during trial or not. And without much consideration to the fact that that is a victimization in and of itself of somebody, because so many of those records turn out to be irrelevant. That's one area where I think the VLCs have been of value. Having somebody who is on that victim's side who can talk through that issue with them, and very often come back and waive privilege as to huge amounts of the records. It turns out in many cases that there was only this one little part of the records that she really had any issue with anybody seeing, and if the VLC can help you to narrow that issue, they can help you to get to a better quality decision. But I echoed many times Colonel Nance's feeling of inadequacy to be doing this, just from in terms of knowing what you're looking at and making the right call. So you have to have your own DSM out and you're looking at things like that.
It's malpractice.
So, probably so. So, yeah. When we talked about experts before, having an expert available to the court maybe to talk to on a confidential basis on something like that would have certainly been helpful, and helpful in deferring that workload issue as well.
Exactly. That's a good thought. I think that's a good thought.
So I had tried cases as a prosecutor under old 412, tried cases as a judge under new 412 and newer 412, and of course even newer 513. We talked early on about the training we had as judges, and the annual sexual assault focused training for judges was invaluable to sort of navigate, okay, what are we doing now and how are we doing it, and who has suggestions on what you do. Perhaps I got it wrong on more than one occasion. I can think of at least one case that the court said I did it wrong under constitutionally required, but it could be a struggle, right? If you don't have a court expert, and I had used a court expert in one case because I had it was a mental health issue. It wasn't even sexual assault. It was a mental health issue for an offender, and so I think using a court expert would be invaluable when you are going to be evaluating mental health records to determine if anything needs to be released. The comment about the requests are shrinking, I would agree that it seems that the number of requests and motions that I was receiving towards the end of my time on the bench seemed to drop, or at least, to be frank, some of the motions were the same every case. I need her mental health records because she saw a therapist. That's not helpful. I mean, seeing a therapist was not necessarily what you needed. You needed to know if she had a mental health disorder. The problem for the court and for counsel is, yes, they might know that somebody sought mental health treatment, but they don't know why. And so what are we missing? What don't we know? And sometimes counsel struggle with that because the VLC doing a great job in protecting their client, but the prosecution may not know what's out there. The defense may not know. They just know there's something. And at least in one particular case I can recall, not for me as a judge, the mental health issue came up in sentencing. And so then now there's this all stop, we have to continue the case and look and see what that is. That's too late in the game for that issue to be now vetted. I mean, it's very late in the game because it comes up in a victim's statement during sentencing. And while in the old days we would look at 513 records for, and I think I did this, I'm certain others did as well, you would look for prior inconsistent statements. Of course, that's not what we do now. We look for the mental health disorders, but I can think back when we were releasing records if there were prior statements in there. now trying to find the mental health disorders that might be there, and counsel for both sides are still unaware of what they are, presents a challenge for the court, because we're being asked to rule on 513 motions without all of the information. Defense counsel motions, well, we think there's something there. Do you have anything more than that? No. Okay, so our hands are tied by the law.
Ms. Long.
This is
And I think then Judge Grimm, that sounded like, okay, thank you again.
yeah.
I want to go back to an issue that came up, I think both Colonel Glass and Colonel Nance raised it about command decision and cases going forward that may not, that the command or someone may not actually believe there is a credible claim or that the person did it, which is something that when you said is concerning. And I'm curious, sort of like the Article 32, if there's some solution you could think of where that command decision to go forward could be subject to attorneys if there is an ethical issue. And I understand that from the civilian perspective and from the military justice perspective, sometimes we differ in terms of the ethical obligations of the prosecutors going forward. Sometimes we've had arguments about whether the rules of professional, not you and me, but in trainings, whether the rules of professional responsibility apply. But obviously in the civilian world, and I would say in any world where we have a criminal case, you don't ever want to just be throwing it up to someone if you don't believe a crime has happened. So is there a solution that checks the decision-making to ensure that cases that ethically should not be done? I'm not talking difficult cases that are complex where we don't know what a jury would do. I'm talking about cases that do not have admissible evidence or do not have credible testimony. And credible meaning there's no testimony, we don't believe the complainant, or we don't have admissible evidence, and someone is throwing that up because they're afraid of not getting promoted. Is there a check on that you could recommend?
Well, I haven't thought of one, but I really believe in our commander's system. And I believe we're different. Military justice is different. And I believe that it should be different. I believe that the commander being involved in the system is hugely important. Will there be times when commanders make an unethical decision? I suppose so, but I think that happens in the civilian justice system as well. I mean, I've never worked in it, but I've paid attention to it, and I think it happens there as well. My experience has been that, and again, we're not talking about the close call, flip a coin cases. We're talking about the unethical decision. I've not seen that. And I think, and I have advised commanders about referral. I didn't spend my entire time as a military judge, although I would have liked to. The commanders take the decision seriously. My experience has been that they take their duty to the system seriously. And though they may feel pressure at times to let and I hope I didn't infer from my earlier comments that the commanders were sending cases that ethically they should not have. But do they feel pressure from without and from the civilians that oversee our military justice system sometimes? Do they feel pressure to send a case that maybe they're not, sure about? I think they do, but I have not had the experience where they know a case is not a true case, not a case that has a chance in the world of success at trial, and they refer that case to trial knowing that. I haven't experienced that.
So I think any honest response to this question involves this disclaimer. When you're a judge, more than any other time in this process, you don't know what you don't know. You don't know what's going on behind the scenes. You don't know if a witness, well, you should know if a witness doesn't show, but you don't know what a witness was supposed to say. So with that caveat, I think there are what I would call bulwarks against that in the system. The question is whether they work and whether those bulwarks are supported sufficiently. So I'll just give you, so I certainly have sat in a courtroom as a judge thinking, how did this get here? I don't even see why we're here. Not he said, she said, credibility call. I'm just not sure. I would tell you extremely infrequently, and I don't know what happened in the SJ meeting with the commander. But I do know that when I have said in classes, so there's a process, or at least used to be a process in the Army, where you have things that are called bridge the gap, which is after a trial, tell people kind of mostly, he's supposed to be technically what they did right or wrong. That waxes and wanes in the service, but there's also, you're supposed to do something called gateway sessions, where you train prosecutors and defense attorneys and talk about legal stuff. I've sat in those systems, or excuse me, in those classes and said, why are you applying a different standard? If you are, why are you applying a different ethical standard to sexual assault cases than you would from just a general crimes case? More emotional, complicated cases, I got all that, but it's the same ethical standard. I've also sat in a room where I thought we were narrowly close to referring just to see what happens. And I think that expression, I'm not in the use of, by Colonel Nance, but that expression in the system is problematic. That's not how the system works. We don't just throw things up against the wall because there's a service member's life on the line. There's a alleged victim who has to come in and pay this price, which there's always a significant, difficult price for that person. I think you can do a couple things to try to make it better. You can vest people with experience so that when they stand up and say, hey, this doesn't work, and I fully agree, the commander, it's a commander-based system, and it ought to be a commander-based system. You can train, right? The Army's really good at training, and the Army's really good at standards. We need to not lose what that standard is. I'm fine with the DOJ standard, right? Civilian Andrew Glass is fine with it. But if that's the standard, we need to train to that standard, and we need to tell people it's okay to walk away when you don't meet that standard. And then some of this is just whoever's advising that commander, whether it's a SVP or an SJA, them having the moral authority to say in writing. I never had a problem with saying in writing. Maybe it's just my lack of intellect. I don't know. But I was always going to say, sir, you shouldn't do this, and here's why. And then some of this, with all due respect, falls to the politicians. Every time a decision doesn't go the way we want it to go, if there's a lynching or a cross burning or whatever your chosen metaphor is, because a commander made a tough call, we got to take a step back and understand that's what we pay commanders to do. That's ultimately what we vest them with, that authority. And so I think there are ethical protections involved. I think we need to train them more. It shocks me sometimes, well, not anymore, but it used to shock me when I'd sit there with young captains and say, what's your ethical standard? Real quick war story. We don't believe her. In a he said, she said, we don't think she's telling the truth. She has affirmatively lied to us in the past. How do we meet the ethical standard? How can we take that to a courtroom if that's all there is? It's no forensics, there's nothing else. To me, that's, I don't know if it's easy, it's never easy, but it's straightforward. That's not a case that goes to trial.
I would say, first of all, as a staff judge advocate, I got the honor of working with commanders who, by and large, actually universally, were some of the most impressive, morally courageous people that I have known. And so, to me, the implication that they would fail to make the tough decision because of career implications, I have not seen any evidence to support that. That being said, I believe, at least when I was staff judge advocate, if the staff judge advocate in his advice to the convening authority said there's no probable cause to go forward, then that took the matter out of the convening authority's hands. He did not have the authority to refer over that recommendation. So there was at least that check in the system before going in. Another thing that I always experience, and I've advised commanders not to go forward on charges, and we've decided not to go forward on charges. And one of the things that we always did was coordinate that decision with the victim's counsel and with the victim. Much like you don't see people suing their doctor for malpractice if the doctor has a good bedside manner. There's a lot to be said for having that relationship with the victim, and even if it's going to be a negative decision, that you thoroughly explain why you're doing that and what all of the thought process was. And I've never had that come back on a commander for doing that. So that's the only comment I had. Thank you.
Well, as a prosecutor, I can recall on occasion doing those memos saying, I don't believe this occurred. That's my personal belief. Does that mean it didn't happen? I can't speak to that. I could just say what the evidence is telling me. I also, though, believe that in the current system, that because we do have some inexperienced or not overly experienced prosecutors handling sexual assault cases, their personal belief that there's nothing here, or their personal belief that I don't find the victim credible, causes concern for whether or not they really can evaluate a case. And does that make them then, if they make that expression, I don't believe her, don't go forward, and then the government chooses to go forward, does that put that government counsel in an ethical quandary? I would suggest no.
Right.
I mean, there are certain cases, I concur with Colonel Glass. Yes, there are cases that came across the bench when I was on the bench that you'd have to think, wow, how did this get through a 32? Did anybody ever talk to this person, this victim? Did they know what he or she was going to say when they came in here? How did it get here? I was the fact finder on a case that ended up at trial where I convicted. And then it came out in the press later that the convening authority had concerns about the case from the get-go. And the question is, well then, convening authority, if you had concerns, why was it at court-martial? Why did you feel it necessary to throw it up at the wall? If you believed, convening authority, that it shouldn't have been there, why did you send it? Because from my perspective as a court, there was sufficient evidence. What was it that caused you concern? And sometimes it's that evidence that doesn't come into court that we don't see. We don't know everything that's going on behind the screen. But convening authorities need to have that ability to say, I'm not going to take it. Don't just throw it up there and let us try to figure it out, or let members try to figure it out. What's the solution for that? I'm not sure. I just know that commanders need to be able to make the hard calls. That's why we pay them the big bucks to do so. They are to make the tough calls. And sometimes they have a prosecutor that may not be giving them the correct advice or good advice, and the staff judge advocate the same thing because of a lack of experience. Thank you.
Judge Grimm?
Thank you very much. I wonder if we could...
A little bit louder,
take
please.
Advantage of your... Can you hear me now? Hopefully you can hear me now. I'd like to take advantage of your experience to shift to another part of the process, namely sentencing. We heard information not from judges. We heard that active duty military judges were reluctant to speak to our committee because they felt that they should not be, because of appellate decisions, explaining a reasoning for a sentence that they imposed at a court-martial, that they should just simply announce the sentence and not explain the reason. When we looked at the actual sentencing, and we're trying to see whether it was confinement or some other sentence that was imposed when the military judge was imposing a sentence, the announcement of a sentence and the reason for it is an enormous portion of the sentencing process in the federal system. And because we have sentencing guidelines that likely would not smartly be transferable to the military, that are very complicated and are an enormous portion of the sentencing process in federal court. But one thing that they do is they require an explanation by the court as to how the court evaluated a number of factors to include the seriousness of the offense and the prior history and characteristics of the defendant and a sentence which is necessary to serve the purpose of sentencing. And there are a lot of other factors that go into that as well. I have met with active duty military judges and was requested to talk about how sentencing occurs in federal court. And there's much of what happens in federal court sentencing that would not be, in my judgment, good to be adopted by the military. But one thing that does strike me as being important in the sentencing process where I live is that if you experience a concern or a reluctance to comment on why it was that you were imposing a sentence, just because you were afraid that the appellate court was not afraid, but you had gotten guidance from the appellate decision saying if you did that you were doing something wrong. And secondly, do you have any thoughts, now that you are retired, about whether or not the convening authority should have the ability to change a sentence when that sentence has been found by a court-martial and imposed by a military judge or by members?
Judge, this is Andrew Glass. So, first of all, with regard to the going through the process, I think, and I'm sure you appreciate, a little bit of it is that in terms of active duty judges speaking to sentencing or speaking in this forum is a concern that something you say may or may not be misconstrued as taking a position that's adverse to the prosecution or the defense. With regard to the appellate issue, I can tell you back as a baby judge, there were so many times, and this isn't directly responsive to your question, but there were so many times where I really felt like in non-sex cases, I felt like the accused really just needed a good butt chewing and really needed to have somebody in a judicial robe tell them they're on the road to perdition, and that would have as much impact, maybe that plus jail or that. And I will tell you, in all candor, I've done it before in cases in which I didn't give jail time or a sentence that was necessarily going to qualify for an appellate review, or an automatic appellate review. I don't see, frankly, any real issue with, I don't see many issues with allowing judges or requiring judges to give some reason for their sentence. But again, some of this goes back to how long have you been a judge and knowing what not to say in that context, not stepping in it when you say something, and not being contrary to what you're right. We only have certain things we can do in sentencing, not being contrary to those things that you're allowed to do. And so think about this. You're junior lieutenant colonel, maybe just promoted, walked into the job, and you haven't done justice in 5 years. And you've been trained, you've been to the judges course, you've been through all these things, and you have a different appellate system. I think it bears mentioning that there's mandatory appeal. No accused has to pay for a transcript to be prepared. No accused, at least on the first level of appeal, has to pay for their attorney. Awesome protections for service members, but everything I do goes up. And so what are the chances that in that system you want that junior lieutenant colonel to get up and say explicitly what happened? So that's one piece. With regard to the convening authority changing the sentence, I believe convening authorities ought to have the ability to change a sentence. Simply put, as a defense counsel when I was young, was able to mitigate sentences for individuals into, for example, non-felonies from felonies where they got a low sentence because it was a relatively mitigated case. and make a huge difference in those service members' lives. I think sometimes, particularly at some of the warfighting divisions and corps, you'll get outlier sentences that are too harsh and that need to be mitigated. So I think the failure to have that ability to do that would be concerning. And I think if you want a fair system, it doesn't look good if at Fort Lee, Bob gets 2 years, and at Fort Campbell, same set of facts, he gets 50. And so I think that's always been a check on the system. And again, I want to echo what I've said before and what other panel members have said. We trust these folks with a heck of a lot of responsibility. And yes, sometimes they quote unquote get it wrong by public perception. But most of the time we trust them to get it right, and they do get it right. And so that's my perception of how that system should operate.
Judge Grimm, this is Jeff Nance. I would be really afraid of a system that would have judges explaining the reasons for their sentence in our current military justice system, where we don't have sentencing reports, we don't have sentencing guidelines and that sort of thing. My fear would be, as Andy mentioned, well, let's put it this way. We would certainly increase the work of the appellate bar. I think whether or not a judge said something that he or she shouldn't have said during explanation about their sentencing, we're going to have more appeals if we do something like that. Is that a reason not to do it? I don't know. I think that thought tells me that the chances of a judge saying something that is either wrong or could be construed as wrong in that process would increase. And so if we did something like that, I think it would need to be very, very narrowly focused. Right now I do bond hearings in the courts that I practice in now, and when I deny a bond or grant a bond, I say I find that the respondent would be a danger to the community because of this conviction and this arrest for this offense, or I find that the respondent would be a flight risk because, and I leave it at that. So something along those lines would have to be implemented to prevent judges from saying things that they perhaps shouldn't say in explaining their sentence. I guess everybody probably knows how I would come down on the ability of the convening authority to change the sentence. I believe in the commander system. I trust our commanders. And I think that they need to have that option, that escape valve option, to correct what I will call the very rare mistakes that occur in cases before they get to them. But the rarity of them doesn't diminish the significance of those mistakes. And having a convening authority who has the ability to say, hey, this was wrong, I'm reducing the sentence, is indispensable.
To articulating the basis for a sentence, there has to be some standard against which that articulation would take place. If the standard is you're giving a sentence somewhere between no punishment and 30 years confinement and a dishonorable discharge, there's really not any reviewable way that you're going to be able to articulate how you arrived at that in the absence of some standard that that is already pre-promulgated and that is out there. Now, as judges, if you give us a standard, we will be able to articulate why we're complying with that standard. We do that when we're dealing with challenges for cause. We know what the standard is for granting that challenge. We can articulate that standard. We can say why this fits within that standard. But if the standard is just, from no punishment to dishonorable discharge in 30 years, then there's really not a framework for us to make those comments. I will say, as much faith as I had in military juries to arrive at a finding of guilt or not guilty, in talking with military juries after trial, they felt completely at sea when it came to the issue of sentencing, almost uniformly, just because of the lack of any real standard between that minimum and the maximum. And so, as a judge, at least I had the experience of having seen enough cases to have kind of an internal barometer, but really nothing more than that. And so, in the absence of standards, I don't know that we would be able to articulate the basis for the sentence in any meaningful way. As far as the convening authority's ability to review and to modify the sentence, I think any system has to have somebody with the clemency power to take care of unforeseeable results. Many times what you get coming out of the back end of a court-martial has no resemblance to anything that anybody foresaw going in, and so, sometimes that's an unjust result, and somebody has to have the power to correct that.
I'll start backwards. I'll start with clemency. When I sat on the Court of Appeals, we used to receive sentence disparity assignments of error regularly, and I know we occasionally would grant the assignment of error and grant some sort of relief in sentencing, but that was rare. Some of the language we would use is that that's clemency. We're not in the position to do clemency. That's not our job. That's the convening authority's job. I don't think the convening authorities should just be limited to perhaps correcting errors, but to grant true clemency. And they don't have that ability in most cases now to grant clemency. So the defense counsel, where traditionally they could go to the convening authority and ask for clemency post-trial, there's really that limited power now. There's not much that the convening authority can give them in clemency. And I would add that the clemency post-trial matters are submitted very quickly after trial. If your argument to the convening authority as a defense counsel is, I want clemency, if you only have 10, 20, 30 days, maybe you can argue that clemency should be granted just as a matter of the type of case it was. But if you're looking for some sort of post-trial conduct that was good on the part of the offender, there isn't any within the first month of trial. If they went to the brig, they don't have good conduct at the brig yet to rely on. Did they do something good for the government post-trial? 10 to 30 days doesn't give a good measure of what their assistance might have been. So I do believe that the convening authority should have that power to be able to not only correct any mistakes, but also to just grant pure clemency, because that traditionally was their role. That's where the clemency came from, not from the appellate courts. When I was I think to use Colonel Glass's analogy or statement, a baby judge, I would very rarely comment on what I gave as a sentence. When I became a little more seasoned after 7, 8 years, I perhaps on more than one occasion would give those comments, but they were very limited because perhaps I was concerned. I sat on the appellate court. I can recall receiving records of trial going, ooh, why did the judge say that? And so it was a bit concerning to be worried about what might be evaluated of what I said. And if I said something, was I going to be challenged in the next case because I made a comment about why I adjudged a certain sentence? Maybe I should have been more deterred in some of the things I did say, but I did make comments about sentences on occasion, and some of those might have been in the cases that didn't reach appellate review because there was no record. The members have no sentencing guidelines. We have no sentencing guidelines. I think we should have sentencing guidelines. I think saying to members, you can sentence up to 30 years, 50 years, whatever it is, or even to a judge, from 0 to 50. Where do you come down? I know as a judge, I kept a binder of every case I did and every sentence I awarded and what the charges were, so that I could look back and see what have I done in prior cases. Every case was treated individually, but I had a record of how I treated other cases too. And if there were unusual sentencing matters, extenuation mitigation, I'd make a note of that. But members don't have that. They have the prosecutor asking for 20, they have the defense counsel asking for 6 months, and they come down wherever they come down. And so now even in the appellate world, you see individuals convicted of sexual assault. Some have very great sentences, some have very little sentence. How is that a fair system? How can an offender who maybe pleaded guilty, or maybe he didn't, but how can he, why is the system set up so that he's serving 7 years and the guy in the cell next to him is serving 2 for almost the same exact offense? I think sentencing guidelines are appropriate.
I'm going to ask the panel if you would indulge us and stay with us just for a few more minutes. We're a little bit past 11, but I think there are some more questions. And I have one. We've been talking about sort of the upstream of the process, the cases that are getting referred to courts-martial. I'd like to just shift a little bit to downstream. When presiding as a judge with a member panel, have you been surprised at a verdict that the members are acquitting when you would have found somebody guilty, particularly when there's issues of incapacitation by alcohol?
I would say not very often, because when you try a judge, or when you try a case to a panel, as a judge, you approach it from an entirely different mindset. I very rarely engaged in the idea of what my result would have been, because I have so many other things to deal with in instructing the panel and in ruling on all of the evidentiary objections. And I'm not sure it was particularly helpful. I also wanted to keep my mind open so that nothing that went into my instructions came across as slanted in one way or the other. And so I think when you're trying a case before a jury, your mindset is so different that it's very rare that you would even make that calculation of whether they got it right or wrong. I have many times when I go talk to members afterwards, they would ask me if they got it wrong or if they got it right. And I'd say, if you went through the process and you believe in your verdict, then you got it right. So I would say the other thing is that, again, I think member panels do an extraordinary job of listening to evidence and applying the instructions and getting to the right result. So it was very rare. I mean, there were cases, and perhaps it's the court reporter who's the better barometer, because there were cases where I'd ask the court reporter what he thought the result was going to be, or she. And sometimes they'd usually be within like a 10% one way or the other. So they might be the better barometer. But I was very rarely surprised by the findings. I was frequently surprised by the sentence, just because the sentences varied so greatly, and because members had so little guidance on how to come down within that spectrum.
I'll be quick. I can't improve on anything Wes said there. I mean, that's my experience exactly.
So I agree with what Wes said about how you listen to a case. And remember, we have no JNOV authority. If it meets the basic threshold of RCM 917, really, which is what I'm listening for, there have been times with that caveat where I've thought, wow, how'd they get there? So remember, I don't know how many, you're talking about very few in what seems like, at least, maybe just because I'm aging, hundreds of cases. And I would also mirror what Wes and Jeff said vis-a-vis sentence. The time where there's usually a point where you're like, really? Is the sentence. And I would tell you, frequently that's to the harshness of a sentence. I was known by the defense bar as a very harsh sentencer. And there were times where I would hear a sentence and think, wow. And so, and on a very, very few occasions, actually wrote a memo to the convening authority when they had that authority to change the sentence, saying that I would say very fair. I think it's twice where I would have sentenced much differently. But that's my observation.
I would agree with Colonel Glass on the sentence, but my wow was more on the leniency in sexual assault cases of sentences. Members don't have any parameters other than what's being asked for by either side, and they come back completely away from anything that any side asked for, and less. And that sometimes was a surprise. But then again, they don't know what cases are, in our view, or the prosecutors or the defense counsel, worth. They just sentence, and I know they take their job seriously because I've interviewed or discussed with members afterwards just their job and what they do. And they take their oath very seriously. But I've had members also express concern about, that was a really tough case. Yes, it was, from all sides. But I'm sorry, but okay, go ahead. But did I ever think they got it wrong on a verdict? No, because I don't go into it from that perspective of what would I have done? And I've had counsel come to me afterwards, so what would you have done, Judge? It's irrelevant what I would have done, and I didn't think of it from that perspective. So.
And I just had an alibi. I think one of the greatest strengths of the military justice system is our professional juries, essentially panels. I think they are smart and they take their duties seriously. They have tremendous experience. And my experience has been that the vast majority of the time, into the 90 percentiles, they're getting it right.
That, I think, though, brings us right back to the acquittal rate. Because if the members are getting it right, and I do disagree with Ms. Long, I think these rates are pretty much unheard of in the civilian system, and I certainly know we brought really difficult cases and had much, much higher conviction rates. So if the members are getting it correct 90% of the time, then the problem seems to be back upstream, if you agree there is a problem.
Or, ma'am, if so the question I would ask back, and at least the rhetorical question is, how long have your prosecutors been doing that job? And the reason I go back to that is because I think it just matters. So when you look at the most experienced prosecutor in the Army, I don't know what that number is, but it's 5-7 years prosecuting cases. That's just not the way it is in district of attorney offices, and that makes a difference, especially with these cases that are almost always, well, that's an overstatement, that very frequently almost like dormitory room. The analogy is dormitory room, Saturday night, a lot of alcohol, little supervision, if any, and it's a he said, she said, and she may not, or he, whoever the victim is, may not remember. And so I think what we're saying is, based on what we see come into the courtroom, based on the evidence that's developed and presented, generally we think they do a very good job of reconciling some very difficult issues, and they take it very seriously. Almost always, if not the entirety of your panel, college educated, vast majority is college educated, experienced people. But the reason why I keep banging this drum is because ultimately, to me, this part is not rocket science. This part really comes down to when you're asking somebody to try some of the very, very hardest cases, often without quote unquote objective evidence that's forensic, sometimes with, you're asking, that's a tough carry for Major Jones, who is the experienced prosecutor, even if they have highly qualified experts to talk to. Some of that is, and you all know this if you've tried cases, some of that's just the feel, okay? What I've heard, pardon my horrible German, referred to as Fingerspitzengefühl, which is just the feel, the knowledge. I've been on my feet so many times arguing this issue where I felt this is what's going on, I need to change. And some of it is the developed people skills to be able to pull those difficult facts out of the victims. And so I don't think they're unreconcilable. I think they're very reconcilable. I think that some of it is, and I would tell you, going back to a question you asked, ma'am, as an SJA, I know that they turned down the cases because they said, nope, we don't want anything to do with this case on a number. And some of that is just a fact. That's just, but I don't think that's the prevailing fact. I think the prevailing fact is that as good as these young men and women are, that we don't keep them in these positions in the Army, I can't speak to anything else, where they develop that feel, where they develop the ability to know this is a good case, this is how you present this evidence. I'll give you a real quick anecdote because I think it matters. I had a case where a special victims prosecutor came in and tried to introduce what were essentially outcry evidence, arguably, from a victim. We don't have an outcry exception to the hearsay rule. The outcry evidence was an excited utterance. Puts on the alleged victim, she testifies and says, I call my best friend and I was upset and I cried and I told him the whole story. When did you call? Things were so crazy I don't remember. Okay, so we all know that there's some exceptions for, could have been a day, a month, a week, really good cross-examination, I don't remember. We know there's exceptions for child victims extending out that time, but I have no time frame. So how's it an excited utterance? How's it admissible? Different, so I don't admit it. Different witness testifies at trial. She's the best friend. She says, I talked to her the next day. Okay? Probably an excited utterance. Probably falls under, because she meets the other piece. And it was a late night kind of assault. The experienced special victim prosecutor does not attempt to reintroduce that evidence. And when told about it in Bridge the Gap, says, I didn't know I could use more than one witness. And kind of seems to imply that I should have sua sponte introduced the evidence, which kind of seems finger on the scales. So to me, that's why I keep hitting that. I think that's the difference. I think that some of it is more difficult cases. And offline we can talk about some of those cases. But I think some of it is just it matters when you've spent time. Reps matter.
I think perhaps the difficult decision is what is a healthy acquittal rate. I would submit 0 is unhealthy because it means we're not taking the difficult cases. 80% is probably unhealthy as well. What is the middle ground in there? That is an indication we're still taking the tough cases, but we're not unnecessarily incurring all of these costs, because there are costs for everybody involved in prosecuting a court-martial. There's cost to the victim in going through the whole process of being interviewed, being cross-examined at trial. There's costs to the accused. Airmen facing court-martial are among our highest suicide risks, and if we really care about that, we have to be thinking about incurring that cost as well when we go into the prosecution decision. And so if we're going to incur all of those costs, what is going to be enough to say it's worth those costs? I think we have to start with investigations. Investigations have to be more thorough. Investigators have to feel at ease to ask the tough questions of alleged victims. I don't think that they always do. I think especially in the last 10 years or so, there has been a real tendency for investigators to take statements at face value and to not ask the probing questions that are only going to get harder to explain as the time of trial approaches. So better investigations, I think, is one thing. Yes. In addition to the trial counsel investigations, ability to read my own handwriting would be helpful. But the other would be trust in the people who have the discretion, the prosecutorial discretion to go forward. I think that's been kind of a theme that is permeated everybody's testimony here today, is that whether it's the staff judge advocate or whether it's the convening authority, we have to trust them. We have to accept that they are on occasion going to make bad decisions, and those decisions sometimes are going to get public scrutiny, but that's the cost of any system. There are going to be bad decisions in any system, and overcorrecting for every bad decision on an anecdotal basis I don't think is the way to go forward. So when you talk about not having the evidence, I think developing the evidence, everything we're telling you is anecdotal, of course. And so I think going back and looking at the evidence and the data to determine really what the next steps are is the best approach.
When you talk about going upstream, I think that upstream is even further upstream. As we know, a lot of the cases we see as judges, whether we were prosecuting them before, defending them now, involve the component of alcohol. And as I read investigations and I read records of trial and I see how much alcohol is involved in these cases that ended up in some sort of sexual assault situation, I often wonder, how is this service member getting to this point when we're supposed to be training them about the effects of alcohol and training them? I know that with the sexual assault training we give to military members, and sometimes they come in and we hear, I know I heard from some of the sappers about they would train one drink is enough. You can't consent with one drink. And we spend, I think, a lot of time educating members that that is not the law. The law is not if you have one drink, you can't consent. Because if that was the law, both of the offender and the victim should be in court-martial because they both were drinking. But we have to do better at that stage, whether it's the training of the military members, intervention. When I see some of these records and I see some of these cases, I wonder, how did we get here and nobody intervened? Why did nobody intervene with this girl who was sloppy drunk and two males are taking her up to a room? Where were the supervisors? Where was the barracks petty officer who saw that? Why did nobody intervene? We talk about bystander intervention, but is it really working? I would beg to say that it might not be, this training that we're giving them. And certainly the training that we then, not only we talk about bystander intervention, but when we tell them that you can't have one drink and consent, I have now in my practice, I have male offenders say to me, alleged offenders, how come I'm the one facing trial? I drank, but so did she. So why am I called the perpetrator when I would view her as being the aggressor? Client's words, she's the aggressor. Why am I called the offender? I can't answer that sometimes for him. That just seems to be the way our process is set up. Most of our offenders that are charged are male. And I think that we need to educate better, way further upstream.
I'm going to take one last question from General Schwenk, and then I'm going to ask us to take just a 10-minute break and maybe start our lunch at 12:15, so we'll have more time.
Okay, but my question is going to turn into two questions. And with all of the authority that I don't have, I'm going to make you, assistant DAC iPad members. Because in the 2020 National Defense Authorization Act, Congress asked the DAC iPad to issue reports on a couple of different issues. And two of the issues I would like to ask your thoughts on. So any thoughts at all are helpful. Okay, the first one has to do with victim impact statements. And I will read from the joint explanatory statement of the conferees and from conference. The conferees recognize the importance of providing survivors of sexual assault an opportunity to provide a full and complete description of the impact of the assault on the survivor during court-martial sentencing hearings related to the offense. The conferees are concerned by reports that some military judges, obviously not retired judges, must be somebody else, some military judges have interpreted RCM 1001C too narrowly, limiting what survivors are permitted to say during sentencing hearings in ways that do not fully inform the court of the impact of the crime on the survivor. Therefore, they ask us to do an assessment and issue a report whether the military judges are according appropriate deference, their word, to victims of crimes who exercise their right to be heard under 1001 at sentencing hearings and appropriately permitting other witnesses to testify about the impact of the crime. So, victim impact comments. please. Thank you.
Sir, was that both questions, or was that? Okay. Okay. So from my perspective, I have limited victim impact statements in the past according to what the rule requires. I've just read the rule and applied the rule. I don't know that I can, in all honesty. I know I've done it. I also know that I've seen victim impact statements that were very, very effective and persuasive, and I've seen victim impact statements that were rambling and not very effective. Maybe all because of victimization. I'm not trying to be insensitive to that. I'm just talking about as an advocate, as a former advocate in the courtroom, I've seen them work very well and I've seen them not work very well. I've seen them be entirely in writing. I've seen them be in, for me, that's okay, but that writing doesn't usually emote very much. There's not much emotion to it. But I guess ultimately the question whether I appropriately limit or whether judges appropriately limit victim impact statements, I mean, to me that's an unanswerable question because I don't know what they're talking about. If when they're saying the rule means this and judges are interpreting this incorrectly, I'm just not sure what the eaches of that is. I would say that in observing practice with victim impact statements, as opposed to, so I'm not sure, I guess, what Congress envisions in terms of the breadth at which they can give a statement and what its purpose is other than allowing them to tell their story, which I understand that purpose. That may or may not be as helpful for achieving a sentence as they may envision it. I would say in terms of the effectiveness of them, my experience goes back a little bit to where before we had that rule where victims would come in and talk about impact. And I think that it's the effective victim impact statements before me have been very, very similar to the victim impact I heard before. Sometimes crushing impacts on their lives and their ability to trust, et cetera. All of that's relevant and admissible under the current rule, but it was relevant and admissible under the former rule. So I'm not sure that answers, and I apologize, just because I'm struggling to try to figure out what exactly the question is. I know it's not your question. So. Yes, sir.
Yes, sir. I have limited victim impact statements before. The occasions that jump to mind are situations where the victim impact statement, excuse me, included comments or references to evidence that I had previously excluded for it being unfairly prejudicial or for some other reason. And so, yeah, I have limited that before, and I don't think that's inappropriate. Otherwise, there's an instruction that we would give. I don't know if it's still in the bench book because I haven't looked at the bench book for a long time, but thank goodness. But there's an instruction we give to the panel members about how and they should consider this victim impact statement. And I think that's a good instruction. It was a product of a lot of thoughtful reflection by a lot of judges. And so I trust everything else that I haven't ruled on previously as being inadmissible to be appropriately covered by that instruction so that the members consider that as they should.
So you're vouching for Colonel Glass that he only did it for evidence that he had excluded also? Must have been his reason.
It had to be the reason.
Okay.
Just has not been my experience. I can't recall having limited a victim impact statement. I've found the victim's legal counsel has done a very good job generally of preparing those and of modifying them if there are rulings throughout the course of the proceedings. So I can't recall a time when I've been in a situation where there was even an objection to a victim impact statement.
I recall making a ruling limiting in some capacity, but I don't recall what it was. I believe, if memory serves me right, it had to do with a recommendation for a particular sentence. And I limited it to that, and they took that out. But I agree with Colonel Moore. I think the victims' legal counsel are doing a pretty good job at helping them prepare. I think the only concern towards the end of my time on the bench before I retired was the timing of it and when it was provided to the government to have an opportunity to review. And sometimes that caused delay because the government was not privy to it until the moment the person was coming in and wanted an opportunity to have a chance to object. But I don't recall any significant items that I had the victim extract out or would not consider. It seemed that they had pretty full range of options to give their statement.
Sir, I do have one alibi, and I know you're trying to get it done, and we all want to take an appropriate break.
No, my wife told me I should lose weight, so I'm not in any rush.
Yes, sir. So I do want to note that the issues that, as I reflect on it, involve notice as required by the rule. Usually that was cured if it needed a cure with some form of recess. In one instance, I can recall an overnight recess. It was near the end of the day anyway. The second did involve specific sentences, which our case law is very clear on a victim recommending a specific sentence. And then the third was it involved the members in a matter that had been previously excluded that to reopen would constitute a mini trial.
Thank you very much. Okay, the other one, as advertised, appointment of guardian ad litem for minor victims. The committee, this is from the House side. The committee is concerned for the welfare of minor military dependents who are victims of an alleged sex-related offense. The committee acknowledges the Department of Defense's continued efforts to implement services in support of service members who are victims, and further to expand some of these services to dependents who are victims. However, the committee remains concerned that there is not an adequate mechanism within the military court-martial process to represent the best interests of minor victims following an alleged sex-related offense. So they ask us for a report that evaluates the need for and the feasibility of establishing a process under which a guardian ad litem may be appointed to represent the interests of a victim of an alleged sex-related offense for people under 18. So, need for, and I guess the feasibility of, practicality of doing so. Thank you. Any thoughts?
Well, I realize that a guardian ad litem has a different role than a special victims counsel, but in the cases where I had child victims, the special victims counsel would undertake to assist the family, the custodial parent to assist the child. I've seen that happen before. I think the need is probably a reasonable need. I think that certainly there are times when the custodial parent's interest might not dovetail with the child victim's interest, and I've seen that happen before, and had to, in my own mind, just sort of worry about, was the child's real interest, both, personal interest and legal interest, being taken care of. I don't know how we would do that. I haven't had a lot of time to think about how we would do that in a military justice system.
Let me just say, in regards to both issues, our door is always opened, our mailbox is always open, the email works, so if you have thoughts later on about any of this, feel free to let us know and we'll include it in our record. Thank you.
Yes, sir. Andy.
Yeah, I would echo what Jeff said and go a little further, I guess, with who does it. I mean, are you going to retain a civilian lawyer, or are you going to take that new to the JAG Corps legal assistance attorney and teach them to be to do all the other things beyond being a victim's counsel, to be a guardian ad litem? And If it's not them, are we then going to take the prosecutor who's got 4 years of experience and tell them their next career position is to be a guardian ad litem, or the defense attorney who ought to be defending that next big case? The problem really is in the details. You absolutely could augment your system by having a civilian attorney come in and do this work. I don't know that at most post camps and station that there is, I don't know. I'm going to stop with I don't know, because what I started to say is I'm just not sure there's enough work to support just one full-time position as guardian ad litem at a small post camp or station. At a bigger one, like a Fort Bragg, there probably is. But they certainly could do some things that junior legal assistance attorney or the special victims counsel may not have the training to do. What I've also observed in the courtroom is that the victims counsel are doing their level best, and that they are doing the things you want them to do in terms of getting to know the child. To the degree those interests compete, though, you don't know what's happening behind the scenes.
And I know that in a lot of places there are private nonprofit organizations that provide guardian ad litem services for children. I wonder if there would be a way that the military could sort of come up with a cooperative agreement with some of those organizations in order to work hand in hand and maybe even provide them some funding to be able to help them, help us provide that. I mean, that's just a thought that just occurred.
Well, as you continue to think about this, please let Colonel Ware know if you have further thoughts. I'm going to give us a 10-minute break, and then we will work through discussing your testimony, which I truly appreciate, and we'll adjourn for lunch then at 12:15. So 10 minutes, but back in seat, please.
Thanks to all of you. I think so. Good talking with you and agreeing with you. Just want to say good to see you.
Mr. Sullivan, thank you and good morning. I want to welcome the members and everybody in attendance today on Valentine's Day to the 16th public meeting of the Defense Advisory Committee on the Investigation, Prosecution, and Defense of Sexual Assault in the Armed Forces, or DAC-IPAD. We're going to begin by taking attendance. General Anderson.
I'm here.
Ms. Cannon.
Here.
Ms. Garvin.
Here.
Mr. Kramer.
Here.
Ms. Long.
Here.
Mr. Markey.
Here.
Dr. Markowitz.
Here.
General Schwenk.
Present.
Dr. Spahn.
Here.
Judge Grimm by telephone.
Telephonically here.
Great. Ms. Tokash by telephone. Ms. Tokash?
I'm here.
Great. Judge Brisbois, Chief McKinley, and Judge Walton could not be in attendance today, but with 11 members present, we have a quorum for this public meeting. The DAC-IPAD was created by the Secretary of Defense in 2016 in accordance with the NDAA for fiscal year 2015 as amended. Our mandate is to advise the Secretary of Defense on the investigation, prosecution, and defense of allegations of sexual assault and other sexual misconduct involving members of the armed forces. Today's meeting is being transcribed, and the complete written transcript will be posted on the DAC-IPAD website. We will begin today's meeting with a panel of retired military judges. The committee has not previously had the opportunity to hear the perspectives of military judges who have presided over sexual assault cases. On today's panel, we will hear from 2 retired Army judges, a retired Navy judge, and a retired Air Force judge. And the committee looks forward to hearing from each of you. Following the military judges panel, the committee will discuss the judges' testimony and then take a break for lunch. In the afternoon, the committee will deliberate and vote on whether to approve the DAC-IPAD's draft 4th annual report. The committee will then receive an update from the staff on its 2020 military installation site visits and members' observations of courts-martial. Next, the Army's Chief of Criminal Law, Colonel Patrick Flaum, will provide the committee with a presentation on the fiscal year 2020 NDAA provisions that affect the DAC IPAD and military justice. The DAC IPAD staff director has informed me that an individual has made a request to provide a public comment at today's meeting. We will hear the comment after Colonel Flaum's presentation. If a member of the audience would like to make a public comment, please direct your request to the DAC IPAD staff director, Colonel Stephen Ware. The comment may be heard at the discretion of the chair, and written public comments may be submitted at any time for committee consideration. Finally, the DAC IPAD staff director will wrap up the meeting and answer any questions the committee may have. Thank you all for being here today. Judges, we are ready to begin. We have your bios, but if you could, please provide us with a short description of your military career, your military judicial experience, and any training you received as a military judge. Thank you so much.
Good morning. Thank you for this opportunity. My name is Bethany Peyton O'Brien. I'm a retired Navy judge advocate and military judge. I spent approximately 9 years on the bench between the trial judiciary and the appellate court. Prior to becoming a military judge, I attended the judge's course in Charlottesville. While I was on the bench, I attended various training, some focused on sexual assault, other trainings such as evidence, scientific evidence, courtroom security, and drug cases. But I'm sorry. Thank you. During the course of my career, I spent 5 years prosecuting sexual assault cases. Thank you.
Hello, I'm Colonel Wes Moore, U.S. Air Force retired. I retired from the United States Air Force after 26 and a half years, 6.5 of those on the trial bench. I also served as a staff judge advocate twice. I've served as a prosecutor and a defense counsel, and now work for the Office of Military Commissions.
Hi, I'm Jeff Nance. I retired after 30 years in the Army. 25 of those years I was involved with military justice in some form or fashion, and more than 13 as a military judge. The training we received included what's already been talked about, the military judge's basic course, and then at least twice annually refresher training on various issues of criminal law and military judge business, including training at the National Judicial College in Reno, Nevada.
Hi, I'm Andrew Glass. 26 years in the Army, was a prosecutor, defense counsel, supervised prosecutors, defense counsel, was a trial judge on 3 different occasions at 3 different locations, culminating being a chief circuit judge with Jeff. Went to the military judges course in Charlottesville, which is a 3-week course, twice. In between my first time as a judge and coming back to the trial judiciary, I was a staff judge advocate, and so they made you go back again. In terms of sexual assault training within the context of being a judge, I tried to remember when we started doing specialized sexual assault training, typically in August of the year. It's a week-long course. I think it's 4 or 5 times. Jeff may have a better memory. When we would go and have intensive courses discussing sexual assault cases, discussing evidentiary issues, for example, and kind of procedural issues that were germane to that issue. I also went to several National Judicial College courses. The ones I recall are a death penalty case. I was actually there with Jeff, advanced evidence, and then some judicial art course.
I think the sexual assault training started in either 2011 or 2012 for judges.
Right, and I should say for Jeff, we both attended and presented, moderated panels, et cetera.
Thank you very much for being here. this committee has in the past heard from, we've heard from victims, we've heard from accused, we've heard from victims' counsel, we've heard from defense attorneys, and we've heard from prosecutors and investigators. But this is our first chance to really have questions for people who've kind of seen the whole thing being put together. So I open it up to questions from the committee. Then I'm going to start. What has been your experience with the VLCs and the SVLCs? Has it changed how the courts-martial proceed, in your opinion, in terms of witness preparedness or surprises seeming to come out for which the complainants have not been prepped? And if each of you could just take a moment.
You don't always have to start with me, but thank you. Feel free to jump in, gents. The VLC program really changed sexual assault cases, in my view. Prior to VLCs being involved, and I look back at even my time in prosecuting these cases, it was a free-for-all against the victim, where oftentimes the victim, male or female, seemed to be sort of dragged through the mud. The VLCs really have stepped up and are protecting them to, I think, an extreme now, because when I prosecuted cases, the victims would come in generally and testify at an Article 32. That was a good opportunity as a prosecutor to see how that individual would fare under cross-examination. They don't have that opportunity anymore. Most victims will assert their rights to not come to an Article 32. Thus, they come into court, it seems sometimes unprepared for what is going to happen and how the questions will come at them. As a judge, cross-examination often was the opportunity for defense counsel to really point out how they prepared with the prosecution and completely refused to talk with the defense. I think that's a disadvantage to the government, to their case, if the victim has never had that opportunity and refuses to, as is their right, understandably so. There have been some bad scenarios with Article 32s, as we know, for the victims being cross-examined. But, and I'm using the phrase victim, alleged victim, but I think in terms of preparation for trial, all they're getting is the ability to prepare with the government. And in some ways, that is not doing them a service, because they are not having that opportunity for cross-examination at any point, or even interviews with the defense. I'll mention that I now have my own practice. I'm a criminal defense attorney. Sexual assault cases are something I defend, and it can be difficult on both sides if that opportunity is not there for victim interviews. Understanding that it's their right, but I think that it would help if they, for the process, would have interviews with counsel on both sides, because then it looks as if, and I saw this as a judge, it looks as if they have something to hide. And we know they don't in most cases, but perhaps they do. I don't know, but it just seems that there's something missing from the process. All you get as a defense counsel now is the CD from an interview with NCIS or CID or OSI, and I don't think they're asking the tough questions either during the investigation. Thank you.
Can I ask a question? This is
I think the
Paul.
VLCs have served a great purpose in empowering victims and in preparing them for what they're about to face. The process is a difficult and ardent process to go through, and one of the best things that the VLCs do is to very realistically describe what that process is going to be like. And I think that's empowering for victims. I think before the VLCs, it was kind of up to the variability, the personality of the individual prosecutor in the case, who was pretty much charged with taking care of the victim. But the victim was not the prosecutor's primary concern.
Gaps and challenges that we've seen from some of the other testimony we received from folks that we have brought in to provide information. I think some of the, I think everybody's concerned about improving the process. I think everybody is genuinely interested in ensuring that the process is fair and equitable, and that the individuals involved in the process have the knowledge, skills, and ability to do their jobs. They have the resources and tools to be able to perform the functions that they need to. I think some of the information that was discussed about the Article 32, I think we have heard lots of different testimony, and literally it's been all over the board about who thinks the Article 32 is valuable and who thinks it's not valuable as it could be or should be. And so that's an area that I know that we've had discussions with and concern about. Also, the referral and referral decisions made by command authorities. We've heard various degrees of testimony about the. Interesting enough, today felt that they were very strong in supporting that current process, and I was trying to resolve the conflict of there was complete confidence in the ability to do that, and yet the SJAs and other staff that are providing the legal information and decision-making process and information for them to make the decision are typically transferred a lot, don't have a lot of experience, not much training, and so you kind of do question, you know, the basis for the command to be able to make a, I don't want to say a really good decision, but a decision based on facts, circumstances, information that is brought to them. So, from the comments I had, thank you.
Ms. Cannon.
With regard to some of the areas that we discussed, I thought that there was kind of overwhelming support for the idea of a 32 being a valuable evidentiary process where a true vetting of the issues is gathered. And one of the participants, one of the judges, was talking about the 4 criteria, which I think are criteria to consider. But certainly that is an underscoring of some of the things that we think are important about the Article 32, and I think supports what we want to be doing. There are a number of things, but the only other one I'll address right now is the point that was raised with regard to experts and defense experts being a really important area where there has to be independence from the prosecution and funding independent from the prosecution. And I thought that was a valuable contribution. And also they said experts for the court, which I thought was also, that's kind of a good idea, it seems. So.
Thank you. So in addition to some of the things that have been raised, and might be reiterating a little bit of Mr. Markey's comments about the need for a process to support specialized, experienced trial attorneys to stay within the system and to therefore create a true special victims unit. I know that they're within the military justice system of prosecutors who are truly able to bring a breadth of experience along with the training and expertise that they may receive to be rewarded, or at least not to be penalized from a career perspective or to be moved around for the needs of the military, to really support people staying in the position, because although there wasn't consensus, I heard enough of it that that was very credible to me. And the second piece about investigations, I think, much like the Article 32, perhaps through investigator training, there has not been enough nuanced training to help people understand how to be victim-centered while still thoughtfully and thoroughly fleshing out an interview and following up on things that may be truly inconsistent or may appear that way, asking follow-up questions in a way that is consistent with good investigations without, barraging a victim or, abusing them. So those are the things that stood out to me today and need to put resources in that.
So I won't reiterate, but I agree with most of what's been said. I wanted to posit, I believe it was Colonel Nance, who I thought posited a good question back to us in the midst of an answer, which was, during the 32 discussion, it was ask what is the purpose, which I know we're talking about, and determine before changes are made, what is the purpose? Is it to get, and this is paraphrased, but to get more convictions or to pull back the curtain, or exactly what is the purpose? So before recommendations are made, I think it's a good reminder to us as a committee and to other future committees that always kind of being at a meta level of what's the purpose of this in the grander analysis of military justice, and keeping that in mind. So I wanted to flag that because I thought it was a very thoughtful answer amidst many thoughtful answers. The other three things I wanted to flag is the expert to the court, very interesting idea, and one that has happened in some civilian courts, which I think is interesting. The recommendation explicitly articulated by one of the judges about sentencing guidelines is something that I think is maybe not on our near horizon of an agenda, but I know there's a lot, but something to consider. And then there was consistency, at least in what I heard, that the SVCs and VLCs are doing a good job overall in what their job is, which is to help the victim and protect the victim, even though that might make the system less smooth at times. But it was articulated by all of them that they seem to be doing their jobs well, which is to protect the rights of the victim. And I didn't want to lose that because in the commentary, there was some, that it could slow down the system, it could result in some delays, but there was also always the note of that they're doing their job. And I think it's important to hear both of those pieces of that.
So one of the things that the four of them emphasized is that the services take cases to trial that the civilian world wouldn't. And I think they said that a number of times. And the question that I have is, and that they didn't really answer, I don't think, is why is that? Is it because they're referring cases to court-martial using a probable cause standard, which many civilian prosecutors' offices would not do, especially in the arena of sexual assault? They would use something approaching a proof beyond a reasonable doubt standard before they would take a case to trial. I know in Los Angeles, that was their explicit standard in sexual assault cases, and they would not refer the case or take the case to trial unless there was some type of corroboration of the victim's allegations. So, I think that's an interesting question is, why might the services be taking cases to trial that the civilian world wouldn't? And they sort of danced around it a bit with the talk about some sort of political pressure to prosecute these cases. And the other thing that struck me, and we kind of ran out of time, or I would have asked them, is the analysis of the yearly data shows that the acquittal rate is much higher for cases that are tried by a panel of members than it is by judges. And yet the judges said that they felt that the panel members were making appropriate decisions, which there's a little bit of disconnect there, although one question that we might ask is, are different kinds of cases going before a panel of members as opposed to going before a judge only? And, that might be something that we can tease out as we start looking at some of the data.
It'd be very interesting to see in the cases that we've documented that alcohol is a factor, are those more likely to go before a panel of members, or are they more likely to go before a judge? I just don't know the answer to that, but I bet we can find out.
I don't have much to add. I agree with Meg regarding her comments about experts, that there need to be resourced, I think, across the defense, the prosecution, and the court to have access to experts. I was struck by one of the judges who commented that they're trying to read the DSM and understand medical information in a victim's file, and to me that's a recipe for error, I think. So I think the experts is really important. And the second one is, I was around when the sentencing guidelines were initially imposed in the federal courts. I was working at the Second Circuit at the time, and there was a great deal of resistance amongst the judges, which over time subsided a bit. But the fact of the matter was there was a huge disparity in sentencing, and then you add the fact that the panels are tasked with making not imposing a sentence, but certainly recommending a sentence. And now you've taken it down to another level where there's going to be a lot of opportunities for a great range of punishment. And so I think that's something to consider very seriously is sentencing guidelines, or something maybe softer than the original version of the sentencing guidelines, but something that provides more guidance to a panel than here's the max and here's the minimum. Pick something in the middle of pick something in that range.
I too will try not to reiterate, although I think I've read something recently about disagreement about whether sentencing guidelines are too high in certain cases. But in any event, and I was actually, we can't, a couple of things. We still can't seem to get an answer of why the acquittal rate is so high compared to the acquittal rate in civilian courts on not only sexual assault cases, but any type of cases. And I can't understand why we can't get a better answer on just we take cases that civilians wouldn't take. I don't know how we would compare that to begin with, but it's troubling that we can't seem to get an answer to that. The alcohol thing is also very troubling, although I have to say they give them training, and they talked about that. The same thing goes on at college campuses. They give them training about that, and routinely alcohol is involved in many sexual assault cases on college campuses. So that one is very troubling, but I'm not sure there's any answer to that at all. It's just a fact of life. The final thing, the sentencing, they all seem to agree that it's a very bad idea to give reasons for sentences, and I would have thought just the opposite, both for the victim and for the defendant, that it seems to me important to give reasons for why the sentence being imposed is being imposed. So that just kind of was strange, without getting into the whole discussion about whether sentencing guidelines are appropriate, which I have strong feelings about. But it just seems to me it would give both parties some kind of idea of why.
Chair. Just a quick comment back. That was in my notes also about that every single judge, I believe all four, commented that they didn't want to put the reasons on the record. And the reason they gave was about appellate review and maybe not saying something they shouldn't say, which flagged in my brain training moments to understand permissibility, but also the sentencing guidelines to understand range. But if you're thinking about procedural justice, The more transparency there is at every step of the process, the more the accused and the victim, as well as the other system actors, can understand and have faith in system. And so I found those comments, while understandable, also a little disturbing through a procedural justice lens.
I would be curious to follow up on the pilot program that was pointed out by Colonel Glass when we were discussing staying in your position as a prosecutor or a defense attorney, and somehow there is a program going on, a pilot program in the Army. I'm not familiar with that. Maybe somebody here is, but I would like to know more about that program. The other question that came up with regard to preliminary hearings and going toward the usefulness of them today is how often is a 32 waived by the defense as being unhelpful in any way? So I would be curious about that statistic.
I think we've gathered that data.
Do you have that one? Okay.
I don't know it off the top of my head, but we have it.
Find it. Fine.
If I may, on the 32 also, and I guess this might be a transcript question for later, but while there seemed to be consistency of depending on the purpose, a more robust 32 that involves some, I believe, evidentiary ideas, I didn't hear any of them articulating a return to the previous 32. In fact, I believe they all said the opposite of that and included that they weren't asking for the cross-examination of the victim. I at least heard one of the judges say that. So it's about what I heard, and I'd like to look back through the transcript a bit, but it's about ensuring defense can get witnesses in the room, other witnesses potentially, and have testimonial moments, but perhaps not a return to the victim being in the space.
I have a comment.
Ms. Tokash?
Yes, I
And I have one after her. I have one after her.
So I'll go first, Judge Grimm.
No, please, please.
Okay, I agree with Mr. Kramer that we need to get behind this alleged notion that the military is taking cases that the civilians aren't. I heard from the judges today characterize what are considered hard cases, or the military is taking hard cases. But I think we need to determine, is the military characterizing these cases as hard because of the facts or because they don't have a prosecution standard that civilian prosecutors have? So by way of example, many assistant United States attorneys are taking to trial what they could characterize as hard cases involving sex assault. For example, sex assault on airplanes in flight, sex trafficking cases, child exploitation cases, but we still take them to trial because prosecutorial decision-making processes in the Department of Justice are evidence-driven. And I was primarily struck by Colonel Glass's comment that the prosecution standards in the military and civilian systems are, I believe he said, dramatically different, and that sometimes he found himself saying, how are we here? Why are we here? If we are here, then something went really wrong with the case, or you didn't really consider that this case should be seen the inside of the courtroom. And then Colonel Nance followed on by saying, we have to look introspectively and determine what is ours, that being the military's purpose, and that perhaps a higher standard will reduce the number of bad cases and acquittals. I think that this is so important, and I think that we need to keep examining this.
Judge Grimm?
Thank you. I have some very specific comments, but I want to start off by thanking the judges for their time. They make me feel very proud that the military could attract people of their dedication, thoughtfulness, and service. So I want to just express that. A couple of observations. Number one, standard for bringing a case to trial. I agree with Ms. Tokash and the others who have commented about that. This is critical. A standard that requires admissible evidence sufficient to move forward seems to me to be an essential clarification that we should consider and explore, number one. Number two, a sentencing standard. What I heard was a reluctance on the part of some of our distinguished panelists to rush into an area and express a view without a standard, and that if there was a standard that could govern. My thoughts are it is essential to have a standard for a sentence that's imposed. I share Mr. Kramer's concern about the guidelines approach, but there should be a standard, and every sentence, whether recommended by a panel or a judge, should meet that standard. And I think it is essential, as one of our colleagues said, for transparency, to explain what the reason is. To simply go from nothing, a reprimand up to 30 years with no explanation seems to me to be disruptive for the system and to invite criticism about the transparency, the consistency of the system, and to the ultimate detriment of the phenomenal efforts that the military has made to try to get its arms around this issue. Experience of attorneys, that is an important factor. I don't know how. I think there'd be tremendous pushback by certain areas in the military to have career paths for prosecutors, but these are hard cases, and regardless of the standards, and if you make a standard, the admissibility of evidence, it highlights the need to have people with the experience to be able to do it. And it advantages no one to have inexperienced folks doing this, because it's not fair for the victim, it's not fair for the defendant, the accused, it's not fair for the military. Experts, it's something needs to be done to give equal access to experts, to government, and to defense, and to the court where needed, without going through some cadre of bean counters who view this as being nothing more than a long and demanding process to justify it. Alcohol seems an enormously significant factor here, which should surprise no one, as Mr. Kramer said, because we have a phenomenally large population of young people in that same demographic as the college kids, where who not only is there alcohol present, but have, at least according to some of the information I've heard from sources outside of this panel, or this group and our committee, where binge drinking is not just simply a phenomenon, but it is a goal. Drink for the purpose of becoming so under the influence that you don't know what's going on. And that's a phenomenon that exists among this age group, and it's a real problem because so much of this includes alcohol. And when alcohol is involved, it makes the facts more difficult as to whose version you believe. And I think the guardian ad litem is, an interesting idea, but I will tell you, in the federal system, we have a statute allowing for a guardian ad litem, but there is no funding. And if you're going to require it, it has to have funding. Otherwise, all you're doing is creating an expectation that cannot be fulfilled.
Thank you. Ms. Longley,
briefly, just on the conviction rates, because this is an area that we are steeped deep in, I really want to say it's certainly an area to spend time to look into, but there is no comprehensive evidence, and that exists actually shows the civilian rate is much worse than what we're talking about here. But every 2,600 jurisdictions, each one of them has a different rate of prosecution and a different number of cases going forward. We cannot look to the U.S. Attorney's Office. They simply do not do these cases. They don't handle the same cases that state and local do with the same volume, and they don't have jurisdiction to do it. The few that they do, and I mean sex trafficking as well, I think one of the challenges when we work with them is just knowing that they are prosecuting all of the cases that exist. But I think this is one of the big questions across our country. Not only what is the actual rate of convictions, but how do we measure like case to like case? And I think that there's ways of doing it, but we haven't done it yet. So I think people think they know what their conviction rate is, but when you look at the data, I don't think it's what they think that it is. So I just would like to caution us to mark this as something to really look into and try and make the comparison.
Just one thing.
Very, very briefly.
I agree, and I think it also depends on whether you calculate convictions based on reports, based on, in the civilian world, based on arrests, or based on cases that are taken to trial. In Los Angeles, I just pulled up our data, there were 5 acquittals out of 5,000 cases, 5,000 reports. So 5 acquittals out of 5,000 reports, but there were only 600 arrests out of 5,000. How many were tried? Well, I don't know how many were tried because some of them pled. 390 were convicted.
So 190 out of 5,000.
390.
390 out of 5,000. I mean,
It depends on what your denominator is.
right, but you have to care about that denominator of what is happening. What was that big number again?
5,031.
5,031. So does that mean that 4,000 of them are false? That's the question we have to get. And this panel can do it, or these smart people. But you have to get there first before we start doing it. Sorry, Chair.
Back at 1 o'clock.
The Defense Advisory Committee's day-long event on sexual assaults in the military is taking a lunch break now. They're expected back around 1 p.m. Eastern.